My name is Rob Clements. I'm from Elmwood. I represent Legislative District 2. I serve as chair of this committee. We'll start off by having members do self-introductions, starting with my far right.
I'm Steve Erdman, District 47.
Lauren Lippincott, District 34.
Robert Dover, District 19.
Myron Dorn, District 30.
We may have other senators who come and go during the hearing because they have bills and other committees to present. Assisting the committee today is Tamara Hunt, our committee clerk. To my left is our fiscal analyst, Kimmy Boggs. Got it. And our page today is Kate from Kansas and UNL student. And Malcolm's looking for chairs. We'll try to provide some more chairs for you. Sorry about this. At the entrance, you'll find green testifier sheets on the table. If you're planning to testify today, please fill out a green testifier sheet and hand it to the committee clerk when you come up to testify. If you will not be testifying but want to go on record as having a position on a bill being heard today, there are white sign-in sheets at the entrance where you may leave your name and related information. These sign-in sheets will become exhibits in the permanent record after today's hearing. To better facilitate today's proceeding, I ask that you abide by the following procedures. Please silence your cell phones. For bills, the order of testimony will be introducer, proponents, opponents, neutral, and closing. When we hear testimony regarding agencies, we will first hear from a representative of the agency. Then we will hear testimony from anyone who wishes to speak on the agency's budget request. When you come to testify, spell your first and last name for the record before you testify. Be concise. We request that you limit your testimony to 5 minutes or less. Written materials may be distributed to committee members as exhibits only while testimony is being offered. Hand them to the page for distribution when you come up to testify. If you have written testimony but do not have 12 copies, please raise your hand now so the page can make copies for you. With that, we'll begin today's hearing with Agency 5, Supreme Court. Welcome.
Thank you very much, and good afternoon, Chairman Clements and members of the Appropriations Committee. My name is Mike Heavican. Mike is spelled M-I-K-E. That's the easy one. The harder one is H-E-A-V-I-C-A-N. I am the Chief Justice of the Nebraska Supreme Court, testifying on the committee's preliminary recommendations for the next biennium. Our current general fund base budget is $244,507,409 plus $27,233,653 of cash funds and $1,495,332 of federal funds for a total, including carryover appropriations, of $273,236,394. We are requesting an increase of, this is a general fund increase of $20,758,729 for fiscal year 23-24 and $27,974 or $974,932 for fiscal year 24-25. By order of priority, these increases are for the following items. First of all, salary increases and adjustments as per our recent salary survey, a copy of which is included in your materials. Like all employers, we have to be competitive in this tight labor market. Our employees are frequently paid less than comparable county and city employees in the same courthouses or municipal buildings. Our probation officers find better salaries in Iowa or Wyoming and with federal probation services. We have a particularly difficult time competing with county salaries in Douglas, Sarpy, and Lancaster counties, but also sometimes find ourselves unable to attract employees in greater Nebraska, and that is particularly applicable to probation officers. The salary survey process began in 2021 when, with your funding support, the recommendations for our court staff were implemented. This current request implements step 2 of the survey's recommendations for the remainder of our judicial branch employees, specifically probation and administrative staff. The cost for this is $6.4 million for fiscal year 23-24 and $6.7 million for fiscal year 24-25. Secondly, we have judges ready and willing to expand problem-solving court options, but we must have increased funding for probation supervisory staff and treatment services to do so. Judge Nathan Cox wishes to establish a veterans treatment court in Sarpy County. Judge Jason Bergevin wishes to establish a drug court in Platte County, and Judge Tina Mariquin wants to expand her current drug court in Saunders County. The cost for this is $935,347 for fiscal year 23-24 and $952,445 for fiscal year 24-25. Thirdly, increased provider rates for mental health, substance abuse treatment, and other services. I will discuss use of carryover funds later, but request that our base appropriation be increased not just for fiscal year 24-25, but also for fiscal year 23-24. It is our understanding that Appropriations Committee practice has been that existing funds are used temporarily to increase base appropriations going forward. The cost of that is $3.6 million. And fourth, property tax relief for counties with ex officio clerks of the district court. As you may know, 28 of our smaller counties have elected county clerks who also serve in other capacities. They are county employees, but among those capacities include serving as ex officio clerks of the district court. 10 other counties have entered into contracts with us to combine their clerks of the district court functions with our clerks of the county court. Ex officio court duties are a current function of county government that for property tax relief and judicial economy should be transferred to the judicial branch. The cost of that is $1.8 million for fiscal year 23-24 and $1.9 million for fiscal year 24-25. And finally, as part of our efforts to always do things better, we have completed a workload study for our probation officers. To begin implementing the study's findings, we are requesting 10 adult probation officers in fiscal year 23-24 and 10 more probation officers in fiscal year 24-25. Probation is an integral part of the criminal justice system, as you are aware. To protect the public and maximize probation's effectiveness, optimal workloads must be maintained. A copy of that study is in your packet also. As you know, the governor included both the funding and PSL for this request in his recommendation. The cost of that is $1 million for fiscal year 23-24 and $2.1 million for fiscal year 24-25. There are at least two ways to pay for these requests. As you are aware, we have considerable potential carryover available to cover most of these expenditures for the next biennium. These, however, are largely ongoing expenses, hence our preference and recommendation would be that you increase our base budget for the upcoming budget years and that we return our potential carryover to the general fund. The second possibility is that we keep the carryover, but our PSL is increased. That approach, however, just kicks the can into future budget years where much greater base increases would be required to maintain judicial branch operations. And we would certainly request that if that is the option you choose, that you make a public commitment so that those base increases will be covered in the future. We have had less than good experiences from such commitments in the past. Resources change, legislators change, and promises evaporate. Regardless of which option you choose, we also need to have you reappropriate all June 30th, 2023 general fund balances, and of course, then maybe different balances depending on which option you choose. Continue estimated cash fund spending authority, continue authority to transfer general fund appropriations and or PSL between budget programs, and include additional funds to probation for any committee recommendations related to service provider rate increases that I haven't already touched on. I also need to remind you that judges' salary increases are a separate budget item. The bill authorizing those increases goes through the Judiciary Committee. The anticipated dollar amount for those increases is $2.2 million for fiscal year 23-24 and $4.5 million for fiscal year 24-25. We just don't want you to leave that out. Thank you again for this opportunity, and I'm happy to take questions, and I've got staff here in case I don't know the answer to your questions, or if none of us know the answer today, we'll get that material to you.
Thank you. Are there any questions from the committee? Seeing none, thank you, Chief Havigan.
Thank you very much.
Are there other testifiers regarding the Supreme Court Agency 5?
Good afternoon, Chairman Clements and members of the Appropriations Committee. My name is Liz Neely, L-I-Z-N-E-E-L-E-Y. I'm the Executive Director of the Nebraska State Bar Association and here today in support of the Judicial Branch's budget request. The Judicial Branch has worked hard to be good stewards of its resources and has embraced the use of technology to bring better service and more efficiency to our system in Nebraska. It's imperative that an appropriate level of funding be made available to enable the courts and probation to manage its functions properly. Access to justice and the right to fair proceedings are not properly guaranteed if a case cannot be considered within a reasonable time by a court that has appropriate funds and resources in order to perform efficiently. In other words, justice delayed is justice denied. Judicial branch staff keep the wheels of justice turning. In response to retirements in a highly competitive job market, the branch has experienced turnover and a high number of vacancies. It's imperative that they are able to implement the salary increases necessary to recruit and retain high-quality personnel, including funding for an additional 20 probation officer positions and adequate funding for the provider rate increase. Adequate workloads, access to services, they're essential to ensuring successful probation outcomes. And as the chief explained in his State of the Judiciary, it is much more cost-effective for our state to supervise adults on probation compared to those who are incarcerated. Also, as a state, we must continue investing in problem-solving courts. They're effective, they save money. We strongly support the Judicial Branch's request to sustain current problem-solving courts and adding a Veterans Court in Sarpy County and a Drug Court in Platte County. In closing, I want to thank the Appropriations Committee for your support of the Judicial Branch and for your work on behalf of the citizens of Nebraska. Thank you.
Thank you. Are there questions from the committee? Seeing none, thank you for your testimony. Do we have other testifiers regarding the Supreme Court budget today? Anyone in the proponent, opponent, or neutral? Seeing none, do we have any position comments? We do. And I have one proponent position comment for the hearing record. With that, we will conclude Agency 5 and we'll open the hearing for Agency 15, Board of Pardons and Parole.
Good afternoon, Chair Clements, members of the Appropriation Committee. My name is Rosalind Cotton, ROSALYN, I am the chairperson of the Board of Parole. I have been the member of the Board of Parole for 18 years, and I've been the appointed chairperson since 2015. As chair of the board, I'm statutorily tasked with supervising the administration and operations of the Board of Parole. I'm here before you today to testify to the requested appropriations for the Board of Parole and its Division of Parole Supervision. The board supports the governor's recommendations for the agency budget request. The requested increases from 2021 to 2023 budget reflect three components. First, planned salary increases and health insurance premium funding are self-explanatory, and we appreciate the committee's ongoing support for our board members and employees. Second, the board and its Division of Parole Supervision have initiated a pilot project to address individuals who have technical violations of the conditions of parole and need swift and certain interventions short of parole revocation. The pilot project is a PrEP house, which stands for Parole Reset Program. This program, as I mentioned, is initially designed to assist current parole clients who need some additional supports to be successful in the community. Carryover dollars within the board's current budget serves as initial funding source for this pilot. This includes rent and staffing and other startup costs such as furnishing equipment and security systems. On a going forward basis, we are asking for general fund dollars and salary limit increases to continue this project through fiscal year 24 to 25. Long range, we expect to see a cost savings as fewer individuals are returned to incarceration in the facilities operated by the Nebraska Department of Correctional Services. We anticipate that with the success of this pilot project, there is potential for expansion in terms of replicating the model for technical violations in other communities and for offering similar programs for individuals being released from incarceration. These are initiatives that can be one piece of the puzzle for addressing prison overcrowding and reducing recidivism of previously incarcerated individuals. Third, the past and current carryover dollars being used to commence the PrEP house at the onset are reflective of the commitment of the Board of Parole has made to assist individuals reentering the community from incarceration. As the number of needs of parole clients have increased, the board and its Division of Parole Supervision have increased the number of services offered to parole clients to remove barriers to success in the community. Past and current carryover dollars have been used to fund transitional housing, mental health, and treatment services with contracted providers for clients, residential substance abuse treatment at Valley Hope, short custodial sanctions in contracted county jails, and taking on the funding of electronic monitoring services for clients to enhance public confidence and safety. We request the committee to continue to provide the agency the authority to carry over unspent general fund appropriations from one fiscal year to the next. I hope this information is helpful to the task you have as Appropriations Committee. We are grateful for the support and confidence this committee has shown to the Board of Parole in the past. We take very seriously the responsibility of paroling individuals who are best prepared to re-enter communities and setting them up for success to the greatest extent reasonable possible with appropriate accountability and guardrails in place. If you have specific questions regarding the Division of Parole Supervision, Director of Supervision and Services, Julie Missick, is here with me today. If there are no questions, we again thank you for your time and consideration.
Thank you. The questions? Senator Armendariz?
Yeah, thank you. Thank you, Senator. Thanks for being here today. Can you just define what an example of a technical violation would be?
Residents, they can't find a residence. Employment, anything that specifies what they need to do with the conditions of parole. There are some other small technical violations, maybe like traffic infraction, something that we can continue to work with these individuals rather than bringing them back to the Department of Correctional Services. I would like to add to that there are times where individuals, for instance, if we do Valley Hope as a period of time for treatment, that they will have a place to go to that our residents versus going back to another transitional living facility. They will basically be able to come to us.
So are the technical violations outlined anywhere specific, or is it subjective to the parole
The
officer?
technical violations are outlined in the conditions of their parole.
Perfect, thanks.
Senator Lippincott.
Yes, sir. Do other states have this parole reset program?
This is what I'm gonna tell you, Senator. Nebraska will be the first that I know of that will be doing a program such as this.
How long do you anticipate that program would be?
It can be anywhere from 30 days to possibly 6 months. It depends on what's going on with that particular client. The key is to get them in a position where they continue to work, they can continue treatment, their services, whatever we have to do with them within our program, and then be able to help them be successful in the long run, and hopefully not see them back in the prison system again.
Senator Medeiros.
Sorry. One more follow-up question.
Sure.
Do you anticipate a location where the prep house will be?
The prep house is going to be in North Omaha, approximately 29th and Cummings.
Senator Erdman.
Thank you, Senator Clements. Thank you for coming today. Very interesting. So what's been your experience with Belly Hope?
Very good experience, great experience. They work with our clients accordingly. They provide the assessments that we need so that the parole officer can continue to work with them once they transition back into the community. And perhaps if they do need additional assistance, then the parole officer is going to work with them accordingly.
Thank you.
I wish we had more.
And when did you start this parole reset program?
We actually started looking at houses, I'm gonna say almost 2 years ago. We just actually ran across this one back in, I wanna say, early spring of 2022. And we were able to find this one and get it ready for our services.
So it's been operating for over a year?
It has not been operating. We basically just started looking for a place. We have a place, but it has not opened yet.
Oh, I see.
Yes.
All right. Thank you. Seeing no questions, thank you for your testimony.
Thank you all.
And we welcome other testifiers regarding Agency 15 Board of Pardons and Parole. Seeing none, do we have any position comments? There's no position comments. That will conclude Agency 15, Pardons and Parole. We will open the hearing for Agency 78, Commission on Law Enforcement and Criminal Justice. Welcome.
Thank you. Good afternoon, Chairman Clements, members of the Appropriations Committee. My name is Don Arp, D-O-N-A-R-P, and I'm the Executive Director of the Nebraska Commission on Law Enforcement and Criminal Justice, otherwise known as the Crime Commission. I'm here today to address our agency budget. The Commission supports Governor Pillen's budget recommendations for the agency. My testimony focuses on 4 key issues. First, the Nebraska Victims of Crime Alert Portal, or what we call NEVCAP. The Victim Alert Service, developed by a commission vendor, launched in late 2021 and replaced what was known as the Victim Information and Notification Everyday or VINE service. Taking notifications in-house provides the commission with more control over system functionality and service costs. We expect future cost savings, but the exact amount will be unknown until after fiscal year 24-25. The commission is not requesting additional funds, but rather an increase in PSL for 2 teammates to manage and operate the software platform. The amounts for FY 2024 are $112,885, and for FY 25, $118,530. Second, Nebraska Law Enforcement Training Center increases in rent and depreciation. The annual rent charged on the training center facility is projected to increase to $878,468 in fiscal year 24-25. This is an increase of $79,861 each year. The annual depreciation charge in the training center facility is projected to increase to $321,538 for fiscal year 24 and fiscal year 25. This is an increase of $33,440 each year. The commission is requesting an increase in general funds for each of the next 2 fiscal years to cover these increases. Third, add a 1.0 FTE to the Crime Victims Reparation Program. The Crime Victim Reparations Program, otherwise known as CVR, assists victims of crime who do not have access to other financial supports with related expenses they suffer from being a victim. The additional employee in the CVR program will allow the agency to process more claims, participate more effectively in efforts to publicize the existence of the program, meaning outreach to victim support groups, law enforcement agencies, county attorneys, and others, and provide for program stability should we experience staff turnover. Currently, the program is administered by one staff person who processes all of the claims. And lastly, server upgrades. In support of the Nebraska Criminal Justice Information System, what we call NCJIS, the commission needs to update related Windows SQL servers, something that was last completed in 2016. This really is the technological backbone of the system. The commission has no other funding to use to cover for this one-time cost, which must be completed no later than July 29, 2024, due to the expiry of the server and the support certificates for the software. In addition to the above items, the commission has been working with the building division in the Department of Administrative Services since mid-2022 on the Law Enforcement Training Center renovation project funded by the American Rescue Plan Act of 2021, otherwise known as ARPA funds. This work has included site visits from our external contractor, interviews with staff, and the development of needed planning documents. We're currently looking at land for the driving track and moving those projects along. And it's very exciting for the commission and for Nebraska law enforcement. I thank you for your time and be glad to answer any questions that you have.
Any questions from the committee? Senator Dorn.
Thank you, Chairman Clemens. I guess thank you for being here. You talked about your upgrade needed to be done by, who requires that? Or what requirement is that by the end of 24 or something?
So we have to have the server and the software updated by July 29th, 2024, because the license for the software expires. The software isn't supported anymore because it's got replaced with a new version. And then the hardware also comes up. So it's kind of a confluence of the hardware and the software all met at one time to expire.
But it's not some federal thing that you need.
No.
Okay, thank you for that clarification.
And my notes say that we did approve that request already. Is that your understanding?
That was my understanding.
Yes.
Thank you.
I agree. And the Law Enforcement Training Center, what's the schedule time for getting that completed?
Well, we have to expend the ARPA funds or have them encumbered by December 31st, 2026. We're currently looking, it's kind of the project model we've taken along with the outside vendor kind of follows a little bit of a domino theory. We have to move our driving track somewhere then free up space for the next project. So we're currently identifying land for the driving track. Our hope is, and we're in preliminary design phase with it to see if it's feasible, of being able to utilize state-owned land to further save some money and have it still be in proximity to the training center. It won't be adjacent, but it'll be within what we consider a reasonable commute, both for training center, basic training, and for Nebraska State Patrol, who will also use the location. With that, once that ground is identified, and if it is state-owned, then it's the site prep work and everything could get going, perhaps even this year or very early next year.
Very good. Senator Armendariz?
Thank you, Chairman. One more question along the lines of real estate. You mentioned a building, is it one building for $800,000? The very first real estate rent increase that you mentioned.
Yeah, so it's for the Nebraska Law Enforcement Training Center, which is one contiguous set of buildings. Kind of like, if you imagine, it's kind of like a community college campus, like a small.
Do you have the square footage for that?
I can get that for you. I don't have it off the top
And
of
what
my
is the rent?
I'd have to get you what the square footage is for the rent and the depreciation. The rent is going up to $878,468, and the assessed depreciation is $321,538. But I can get you the square footage.
Okay, I appreciate that. Thanks.
Other questions? Seeing none, thank you for your
Thank you.
testimony. Are there any other Persons wishing to testify on the Commission on Law Enforcement and Criminal Justice. Welcome.
Thank you. Chairman Clements, members of the Appropriations Committee, my name is Erin Feichtinger, ERINFEICHTINGER. I always feel it's a little unfair to have to spell that name in the time limit. I'm the policy director for the Women's Fund of Omaha, and we're committed to supporting survivors of domestic violence, sexual assault, and child abuse in this state. I'm not here to oppose the funding to the Crime Commission because we believe the funding is imperative. Just here to highlight some of the serious issues that we've seen with the Crime Victims Reparations Program 202 under this agency. We worked on an interim study, LR 412, with Senator Wendy DeBoer, which analyzed the Crime Victims Reparation Program. And what we found in that report was that over half of the applications to that program were being denied. Processing times for applications were incredibly long, which can serve to further traumatize victims in the state of those crimes. So for instance, the statute for the CVR requires that the hearing officer make a decision for a claim within 180 days. If the applicant is denied funds, they have 30 days to appeal that decision and request a hearing from the committee. The committee then has 120 days. All told, for applicants appealing an initial decision, the process can take longer than 330 days or nearly a year before receiving a final decision about their claim. In the course of the interim study, we interviewed victim advocates from across the state, and 35% of respondents said that on average it took more than 5 months for clients to receive a decision about their claims. In June 2022, a provider was made aware by the CVR program of an even more delayed timeline, up to 9 months, to hear about their claim. If the program continues to deny applicants, especially qualified applicants, if they take this long, they're at risk of losing federal funding, kind of a if you don't use it, you lose it situation, which would further jeopardize victims and survivors in this state. Since that report and introducing subsequent bills to facilitate access to this program, we are trying to fix it. We've heard from healthcare providers across the state who are allowed by statute to bill the CVR program directly for any services provided as a result of the crimes of domestic violence, sexual assault, child abuse. They are also finding it very difficult to access that program, resulting in them either writing off those costs, which I'm sure you're familiar with, Senator Armendariz, or just being tens of thousands of dollars in arrears from the inefficiencies of this program. So like I said at the beginning, I'm not here to oppose the funding to this agency, and in fact would strongly suggest that funding continue, albeit with some oversight over the way this program in particular is being administered. This legislature has already decided through the provision of this funding that victims should not be further traumatized by the crimes committed against them. But we are concerned that the inefficiencies in this program mean that this funding isn't going to victims as this legislature has intended them to do. So I'm happy to answer any questions to the best of my ability.
Any questions? Senator Vargas?
Thank you very much for being here. You said about half of the applications have been denied.
Mhm.
You know how many total applications generally there have been?
I don't know the number off the top of my head. I can send you the LR and anybody else on this committee who's interested in that. But it's been fairly consistent that of the people who are applying, about 50%, I think last year's 52% of applicants are being denied in that first round. There's other issues with the program and the appeals process. Some pretty horrific stories about child abuse victims, and
Yeah, if you could send the LR, that'd be helpful.
Absolutely.
For the committee.
Be happy to do that.
Thank you.
Senator Armendariz?
Thank you. Thanks for being here today, and thanks for talking about this. Did you get any feedback of why it takes so long, what the holdup is at the agency, of why it takes so long, and also, let's just start with that.
Okay. We really don't know. There's not a lot of transparency or data available about why victims are being denied in other programs that we've worked with, right, you would have some sort of aggregate data that would say there was denied for not having the correct documentation or denied because they didn't qualify under statute. That information is just not available at this time from the program. And then what was your second question?
Second question was, are there a set standard of what would qualify you? Or I guess you kind of answered, you're not getting told why they're denied, but is there a set outline of qualifying measures that they need to meet?
Yeah, so the victims do receive a letter back from the hearing officer about why they're being denied. Again, we just don't have access to those in terms of like aggregate data. There are qualifications for the program. They have to be, particularly, let's say in the interconnection between healthcare providers billing the program directly, those would have to be services that were provided directly as a result of one of these crimes. So for us in particular, sexual assault, domestic violence, and child abuse. So there are qualifications for that. Later on, there's things like qualified mental health services, lost wages as a result of being a victim of a crime, funeral expenses, particularly on homicide, and all those. And there are qualifications. There are also, and this is not this committee's particular purview, but in other committees, that strict interpretation of eligibility requirements is not particularly trauma-informed or victim-centered, which can have some issues for victims who may have learned about the program one day too late to meet those requirements.
Thanks.
Any other questions from the committee? I'll just make a comment that they did ask for one additional staffer, and we have preliminary approved that. And we had comments that the position was vacant for almost 4 months. And after it was filled, it took several months to train a new employee. And hopefully the agency is working on that, and hopefully that'll help for the future.
And like I said, we're not opposed. We do believe this funding is imperative. I just wanted to make sure that the committee was aware of the issues that we're hearing from victim advocates across the state.
Thank you for your testimony.
Yeah.
There are other testifiers regarding Commission on Law Enforcement and Criminal Justice. Seeing none, do we have any position comments? Seeing none, that will conclude Agency 78. And we will open the hearing for LB 176. Senator Dungan, welcome.
Good afternoon. Almost said good morning. Time just flies, doesn't it? Good afternoon, Chair Clements and members of the Appropriations Committee. I'm Senator George Dungan, Georgedungan. I represent the good people of Northeast Lincoln in Legislative District 26. Today, I'm introducing LB 176. Legislative Bill 176 is a bill that appropriates an additional $600,000 to the Supreme Court from the general fund for fiscal years 23 to 24, and then again in 24 to 25. This additional funding will go to the Supreme Court Agency 5 Program 34 to increase payments for interpreter services for the deaf and hard of hearing, as well as those that are unable to communicate in the English language. Court interpreters have not seen a pay increase since the early 2000s. I believe they've not had a pay increase since 2004. This lack of pay has resulted in many interpreters turning to private practice instead of taking cases within our judicial system. When we can't get an interpreter, cases get rescheduled, needlessly extending proceedings at great cost to the state. Just earlier this week, Chief Justice Heavican in his State of the Judiciary spoke about the importance of court interpreters, stating, quote, "Our contract interpreters are hopeful this body will fund an increase in their daily rates this year," end quote. And that's exactly what LB 176 would do if enacted. There are plenty of experts here to testify in favor of this bill, from interpreters to court officials and members of the Supreme Court, or people who work for the Supreme Court. I want to take a minute to talk a little bit about my own personal experience. For those who don't know, and I've talked about it before, but I'll reiterate, I served as a public defender for nearly a decade. Many of my clients were folks who were not English speakers, and I've worked with people who were deaf or hard of hearing, as well as non-original English speakers. The court interpreters that I worked with were, to put it frankly, incredible. The court interpreters are overworked and underpaid, and we see it every single day. Vast majorities of clients who don't speak English are in all sorts of different courtrooms. And so the interpreters are bouncing from floor to floor, courtroom to courtroom. And when you see how hard they work and the efforts they're putting into it, it's frankly pretty incredible. We have an obligation and a duty, statutory obligation, to make sure that our courts are accessible to those who don't speak English. It's literally something that we must do. And so it's essential to make sure we have court interpreters. In my time as a public defender, I watched some of our incredible court interpreters leave the courthouse and move into the private sector. I applaud them for doing that. Obviously, I think it's fantastic they're doing what they have to do, but one of the main reasons they did that was because they simply weren't getting paid enough to remain working for the actual language access services with the courts. My clients oftentimes saw cases continued, not just for a few days, but for months, because the court interpreter was overworked and unable to come to courtroom 22 where that person had a docket call and maybe was going to have that case resolved. Literally, I've seen cases that would have been resolved that day get continued for 90 days and even longer, again, at great cost to the state. So to me, this is a really good return on investments. It's fulfilling an actual statutory obligation that we have to make sure that our people who are in the court system have access to that court system. And it simply is just the right thing to do. You're going to hear from a number of people after me who are court interpreters, and they can tell you their personal stories, but I just know from my working with them at the public defender's office that they are superheroes who do incredible work and need to be getting compensated for that. Not having had a pay raise since the early 2000s is incredibly problematic, and they definitely work for every penny they're getting, and I think you're going to hear that from them. So happy to answer any questions folks might have, and I would urge your consideration of LB 176.
Any questions? Seeing none, thank you for your testimony, and we now invite proponents for LB 176 to come forward. The first proponent.
Good afternoon. My name is Kelly Vargas, Kelly Varguez, and I am one of Nebraska's court certified Spanish interpreters. In 2007 or so, I left my profession as a public school Spanish teacher because I had two small kids and couldn't figure out how to balance daycare costs with workload and everything. And I found my way in 2009 to court interpreting, and I was overjoyed. I was relieved to find a profession that checked all my boxes for me. It was challenging. It had flexible scheduling. I could use the language skills that I'd worked very hard to develop, and it was well paid enough that I could figure out daycare for my small kids. And the more I offered my services in court, the more inspired I was to learn how much leadership Nebraska had shown at a national level in the early 2000s by establishing a rigorous certification program and requirements, and by offering at what was at that time very competitive wages that attracted talented individuals to our profession. And over my years in the courts, I've really been fortunate not only to work with wonderful public defenders, prosecuting attorneys, judges, court staff, and members of the community who need language access services, but also with an amazing cohort of very qualified interpreters, some of whom were refugees when they came here and they worked their way into a profession like interpreting. Some of whom as children were unfairly asked to interpret for their own parents in some of the most heartbreaking or tense or frightening situations that we can imagine. And Nebraska has shown leadership in saying that that's not good enough for us in our court system. We're not going to let that happen. We need qualified, talented, neutral parties to provide these language access services. But over my 12 years working in the state courts, I have seen personally how, as our wages have stagnated, numbers of new interpreters joining our ranks is dwindling. The last time we welcomed a new certified interpreter of any language to our roster was in 2016. And in 2009, when I was certified, there were at least 3 other people it's certified at the same time. So the numbers have really dropped as our wages have stagnated. And I think that is directly related to how much our purchasing power has fallen over these 19 years that we've gone without any kind of a rate increase. And I think that LB 176 is very much worthy of your support. My colleagues and I do the type of work that allows Nebraska's courts to provide the access to justice that we are so committed to. And I do not want to see a program that has meant so much to me personally and that does such good work for our state languish. So I very much request your support of LB 176 and would be happy to answer any questions.
Questions? Senator Dorn?
Thank you, Senator Clemens, and thank you for being here.
Thank
Do
you.
you know approximately, maybe somebody else can answer it later, approximately how many interpreters there are in the group or whatever?
On our roster, I believe when we initiated the process this year of rate increases, we had a working roster of approximately 40 individuals.
And are they on, they're not all full-time then, they're part-time or as needed, or how's that work?
Only 3 Spanish interpreters statewide are full-time Nebraska state employees. The rest of us are all freelance contractors. And so we are called in as needed. Many of the courts in more rural parts of the state have dedicated days where they bring interpreters in for a full day in order to efficiently use the funding and the court time. In Douglas County, where the volume is higher, there are approximately 4 to 5 Spanish interpreters only in the building every day. And weekly, we have a number of interpreters of other languages, such as languages of the Sudan, of Myanmar, the Middle East present also interpreting. And this also covers ASL. So we have interpreters present for the deaf and hard of hearing. And of that group of people that I've worked personally with, at the Spanish group, I've seen almost, I would guess about 40% of my colleagues move on to different things just since shortly prior to COVID, looking for full-time employment and just no longer available to serve the courts.
Senator Lippincott?
Thank you, sir. Do you get paid per hour, per case? How does that work? And how much is that? Is it graduated pay? And then also, what are the qualifications? Do you have to take a written test, an oral test? How's that work?
The way that this works for all interpreters, whether we've achieved certification or not, is that we are brought in on an as-needed basis for a 2-hour minimum block of time. And we cover the maximum number of cases that we're able to cover in that amount of time. So we're paid $50 an hour, and we're guaranteed a minimum of 2 hours time paid, and we cover whatever number cases are needed that we're available for in that time. And then our registered colleagues who aren't certified yet earn, I believe, $35 an hour for each hour, and they're guaranteed the 2 hours. To become certified, to become registered or certified, you are asked to pass a written exam that tests ethics, knowledge of the court system, and high register English vocabulary. And from there, you move on to an oral exam that tests your ability to interpret simultaneously, which is what you'll see ASL interpreters often do, hearing spoken language and signing as they hear it. We do the same thing with spoken language. Consecutive is used for testimony, so that we don't have too many voices going at once. There's a someone testifies, there's a pause, then the interpretation. Sight translation is the third mode we're tested in, and that's when you read a document in one language and you translate it out loud in real time into your other working language.
Any other questions? Senator Dover?
So you said there's full-time and there's contracted,
Yes,
and then full-time are employees
of the state of Nebraska, to my understanding.
are they part of a union?
Not that I know of.
That's all the questions I have, thank you.
Thank you.
Do you receive any travel mileage expenses?
There is a travel allowance, and it's, I believe, 80% of the hourly fee. So it's a smaller amount than we make hourly. And it's only if the event that you're called to interpret lasts longer than the 2-hour minimum. And we do get paid mileage at the government approved rate. But most of those 40 individuals that I mentioned, from that amount of money, we're paying insurance and, just taxes we reduce from that, all of that stuff. So we don't take home clean that amount of money. And on top of it, it's not that we're working 40 hours a week at that rate. Because of the way the courts work, it wouldn't be efficient to have 44 interpreters paid, 40 hours a week at that rate.
80% of the hourly rate
Is travel time
Travel.
currently.
plus
The way that it's
the federal mileage.
I believe
per
right
month.
now it's something like 62 cents a mile.
Yes.
Some of my colleagues that travel more might be able to
Thank you.
let me know.
Seeing no other questions, thank you for your testimony.
All right, thank you.
Other proponents for LB 176?
Hello again. My name is Maria Arriaga. Oh, thank you. Thank you for your time. My name is Maria Arriaga, M-I-R-I-A, Arriaga, A-R-R-I-A-G-A, and I'm the Executive Director of the Nebraska Latin American Commission. I'm testifying in favor of LB 176. And I want to thank Senator Dungan for introducing this legislation. As you might know, the cost of living around the world has increased considerably, and in this country, it's obviously not exception. And everything, as it commonly says up there, everything goes up except the salaries. So the needs continue. We have to adjust to the expenses that we are facing. And obviously, if the salaries doesn't change, it's a struggle every time and bring us a detriment in the quality of life, obviously. So let's talk now about the importance of having a qualified personnel to be able to interpret the different variants of the language, especially in an area as important as Supreme Court. Many people simply don't understand how complex language can really be until they are confronted with the task of having to move something important from one language to another. I can say from my own experience that this is a very complicated task, especially when it comes to situations in which definitely definitive sentence is at stake. It's incredibly easy for important nuances and a lot of true meaning to get lost in translation if you don't have the services of a qualified interpreter. Quality becomes even more important if you work in a field like medicine or in this case, law. That requires a working understanding of a specialized terminology and complex subject matter. Many times it is believed that interpreting is a matter of how being able to understand the other language and being able to speak it to make it on self-understood. But really interpreting implies giving a real and strict meaning of the phrase in a completely different language with either structural, grammatical, syntactic, terminological, phonetical, and even cultural way. For example, an interpreter from English to Spanish and vice versa has to know the different regionalisms and idioms that all variants of Spanish have. It's not the same Spanish from Spain, it's not the same Spanish from Mexico, Spanish from Chile, and even it's not the same Spanish that we spoke here in the United States, where there are already subcultures that express in Spanglish. So in short, language isn't, and the interpretation, it's an endless study, which is complex and must be valued as such. I personally know how difficult it is to retain staff Currently, with so much competition outside that offers better salaries, of course, I understand the need to look for better options, but at the same time, I'm very concerned that the quality of these services may be diminished due to the lack of personnel or lack of qualified personnel. I believe that a job like this should be recognized with the corresponding increases accordingly to the current situation in the country and according to the cost of living. I stress the preponderance of this matter, and I urge you to advance this bill to the general file. If you have any questions, I'm happy to answer.
Any questions from the committee? Seeing none, thank you for your testimony.
Thank you.
Are there additional proponents for LB 176? Welcome.
Good afternoon, members of the Appropriation Committee. My name is Vladimir Bazan, VLADIMIR, I am a certified court interpreter, Spanish court interpreter in the state of Nebraska, and I have been providing services for the state since 2012. I am one of about 30 certified interpreters in the state at the state level. I am one of 5 interpreters who are certified at the federal level. And I share those numbers with you just to give you an idea of how difficult it is to do what we do and to get certified at what we do. We are not just individuals who happen to be bilingual. We are true professionals, and we play a vital role in the court's mission to guarantee equal access to everyone in Nebraska. We are recognized as officers of the courts, and we follow a professional code of ethics. So we are requesting your support today to guarantee that we receive a just compensation, just like all professionals should. I am also a former interpreter coordinator for the state of Nebraska. Before you were asking questions about full-time interpreters, I used to be a full-time interpreter for the state. For about 8 years, I was in charge of arranging interpreters for the courts and probation offices throughout the state, the last 4 in Lancaster County. I also participated in yearly orientations, which are designed to recruit new court interpreters. So if you want to be certified, if you want to be a court interpreter, you have to attend orientation. Year after year, I became aware of the increasing difficulty to secure interpreters and the increasing demand for those services. The demand for interpreters in the private sector was also a constant challenge for me as a coordinator, since I was well aware that we could not offer rates that would be competitive enough to persuade interpreters to accept jobs in the state courts. Sadly, I also witnessed the reduction in both numbers and quality of candidates who wanted to become court interpreters. Eventually, I myself had to leave what was once it was my dream job in order to avoid the stress, cost of having to secure interpreters all the time, and also to offer my services in the private sector, which was so competitive and still is. Nebraska is one of the pioneers in the country in guaranteeing equal access to justice through the use of professional interpreters. Securing the funds necessary to guarantee just compensation for the state court interpreters is vital to guarantee access to justice to every individual in our state and solidify Nebraska's commitment to bring equality before the law. Thank you very much.
Other questions? Seeing none, thank you for your testimony. Additional proponents for LB 176?
Good afternoon, members of the committee. My name is Constanza Meyer, M-E-I-E-R. I am a certified Spanish interpreter. I have been certified since 2001. It is the second year that the state offered the certification. LB 176 focuses on increasing pay for contract court interpreters. This is an access to justice issue. It is a fundamental right. Language access is equal justice access. Our communities are becoming increasingly diverse, which means there is an increased need for interpreters in the course of all languages. We are integral to justice. Interpretation is a skill, and it should not be assumed that any bilingual person can be an interpreter. The proof of that is that we have not been able to certify any Spanish interpreters since 2014. Unfortunately, we are underpaid and we have not received a pay increase in 18 years. I don't know many people who would stay at the same job, without a rate increase for 18 years. Like all professionals, we deserve just compensation. A pay increase is long overdue. A pay increase would also help attract and retain qualified interpreters to serve this crucial role in our justice system. Thank you for your time.
Any questions? Senator Dover.
So what would be a current wage for an interpreter?
Well, we formed an interpreter advocacy committee, and we are requesting $85 an hour for certified and $60 an hour for registered, which is people who have gone through the orientation, have passed the written English proficiency exam, and have passed 50% of the oral exam.
Would you spell your first name, please?
Constanza.
Thank you.
Thank you.
Are there other questions? Seeing none, thank you for your testimony. Additional proponents for LB 176.
Good afternoon, Chairman Clements and members of the committee. My name is Frankie McGregor, Frankie Macgregor. I'm a certified Spanish interpreter in the state of Nebraska. I have been certified and working in Nebraska courts since 2009. However, last year, I found that I was no longer able to meet the costs of self-employment and managing a household, and I got a part-time job. Until January this year, I was able to take another position as a full-time Spanish interpreter with immigration court, where the pay is higher. I'm given a 3-hour minimum, and I'm guaranteed a 3% pay increase annually. I would gladly return to the state of Nebraska if I could make ends meet with that pay. And besides my own experience, I'm wondering if the committee would allow me to share a letter that was hand-delivered to us from a judge this week.
Yes.
Okay. Thank you. This is from Judge Jeffrey C. Hall, District Court Judge of Dodge County, 6th Judicial District. Dated February 21st, 2023, addressed to the Nebraska Unicameral Appropriations Committee. Ray, support of LB 176. Dear Chairman and members of the committee, please consider this letter my support of LB 176, introduced by Senator Dungan. In my experience as a district judge, I have found our court-certified interpreters to be an extremely valuable part of the legal process here in Nebraska. Unfortunately, these dedicated individuals are underpaid and have not received a pay increase in over 2 decades. In the District Court of Dodge County, we have a growing need for qualified interpreters to help individuals navigate the court system. I believe that a pay increase is long overdue and will help attract and retain qualified interpreters to serve in this crucial role. Sincerely, Jeffrey C. Hall.
Thank you. Are there questions from the committee? Senator Dover?
What's the current rate? Excuse me, what is the rate you're currently being paid in your new position?
$53.96.
Does that include any other benefits or
No.
travel?
For travel, I would get an extra hour of pay every day.
Any other questions? Seeing none, thank you for your testimony. Additional proponents for LB 176? Welcome.
Good afternoon, Chairman, members of the Appropriations Committee. My name is Dale Taylor, DALE TAYLOR. I may be one of the earliest ones certified in the state. I came in 2000 here to the state of Nebraska, up from Mexico. And I went into the Madison County Courthouse at that time because there was someone in front of the window needing some interpretation, and there was nobody back there that could answer their questions or could know what they were even wanting to do. So I stepped in and said, hey, can I help you? And so I did. And they said, would you help us more? Because we have those situations all the time. So I said, sure, I'd love to. So that was what started my my career in court interpreting. That was back in 2001. In 2002, I began to do it more full time. And it was in 2005 when I was certified as a court interpreter. I was one of the earlier ones because of the certification that was proposed. Now, before that time, there was no certification process. And so, as has been mentioned by a previous colleague here, Nebraska was very a forerunner in some of that process of certifying, getting people that were actually working in the courts that were qualified for that position, that were actually able to do a job that was worthy of the courts. Since that time, nothing, well, at that time, there was a wage established. It was considered quite meager. And then in 2004 or 2005, I believe it went to the current rate. And that is what we've been working at that time. I concur with my other colleagues with regards to the fact that it no longer sustains us as interpreters. In fact, on the private level, I am able to charge other companies, other attorneys privately, $100 an hour for my services. There are other colleagues of mine in other places that charge more than that, 110, 115. And so those are the wages that we can actually charge on the private sector doing just private contract work. One of the challenges that we have is because as a professional interpreter, because it is only as you are needed, if I don't generate enough income through my professional interpreting to support the family, then I'm obligated to find a job that will. And so I may look at the public sector where I can work then a regular 40-hour work week and earn the money that I need to support my family. And so there is that need to be able to not only provide enough service, enough work, but then to make it worthwhile where that I could then, out of my pay, can pay for health and for my taxes and for childcare if that's possible or if that's needed and so forth. And so when you consider that being the not a net, then there's a lot that comes off the top. And so I am here just to say, personally myself, I have turned down many opportunities to work in the courts because I have a better paying gig on the private sector. Obviously, it's a matter of economics. Why take a 50-hour job work when I could actually earn 100? So it's just a matter of dollars and cents in some ways for us. And the problem is that if it doesn't get raised, then we're going to have a harder and harder time to secure interpreters. In fact, right now, basically, I do it because I take pity on my coworkers because they're overworked or because they can't find anybody. And so they'll call me and say, hey, Dale, I really need you right now because there's nobody taking this thing and we're stuck. And so I'll say, okay, fine. And then I'll take a job. But that's just the brass tacks, I guess. I just want to give that personal opinion and support of that. Thank you.
All right, any questions from the committee? Seeing none, thank you, Mr. Taylor.
Thank you, Your Honor.
Are there other proponents for LB 176? Welcome.
Thank you. Good afternoon. My name is Luna Jongsas, which is LUNATSANG-SAHS. And I'm a registered Nebraska court interpreter. And this is my freelance job. And I started back in 2002. And when I attended the orientation, in order to be the Nebraska court interpreter, you have to attend the orientation, and also, as mentioned, that you have to pass the written test and also the oral exam. And back then, you don't need to pay anything to be getting to the orientation, and also regarding to the written test, you don't have to pay anything unless you fail. Then you have to pay for the second test, and the oral test, you have to pay for it. And then, as I said, that it was back in 2002, and it's back in 2000, I think like back in 2015 or something like that. Actually, it's back to a couple of years ago, and I have been working as a court interpreter, and but this is just my part-time job because it's as needed, and my language. I've got to mention my language, of course. I'm one of the Mandarin interpreters, and I'm the only Cantonese court interpreters, and for that, and because as Senator Duncan mentioned earlier, that it's not easy to be a court interpreter because Nebraska required a high level, and I have to keep on updating and keep on the training and stuff, and you have to use your own expense. It's not for the pay rate, and since 2002, actually, I didn't see any raise at all. So it's 2023 now, and over 20 years, not even a one dime. That is kind of upsetting, but it's kind of hard to do it, and especially when it's needed, and a lot of times we're being called like the very last minute, or maybe within a very short time notice, and also when we get to the courtroom and we don't know which courtroom that we're going to, and they always change courtroom at the last minute also, and they don't have communication, and they don't let us know. So when we got there, we were like doing like a scavenger hunt, trying to go through all the places, all the courtroom, find out which one it is, and it's frustrating. And when you get there and you find out that you're late already, and then the case is already done, and I believe in everybody have a fair trial, and because of that, and people who doesn't speak English and should have a fair trial too, and that's what the court interpreters is for. And it just a little bit frustrating, but like I said, we do have minimum pay for 2 hours, and but for my understanding, in the federal level, and is because only over 2 hours, then you can get extra interpreters for help. And being an interpreter, as even training in the orientation training mentioned that if you bilingual doesn't mean that you can be an interpreter. You have to be trained and you have to be professional and ethical. So because of that, it's not easy to be one, and so yeah, that's all I can say, I guess. Thank you.
Okay, very good. Any questions? Seeing none, thank you for your testimony.
Thank you.
Other proponents for LB 176, please come forward. Welcome.
Thank you. My name is Raul Escobar. I'm a certified Spanish interpreter. I was the interpreter coordinator and in-house interpreter here at Lancaster County for 10 years.
Would you spell your name, please?
Yes, sorry. Raul, R-A-U-L. Escobar, E-S-C-O-B-A-R.
Thank you.
Sorry about my voice. I interpret all day long and it just kind of goes away after a while.
Would you start over, please?
Sure.
All right.
I'm a certified Spanish interpreter through the Nebraska Supreme Court. I started interpreting in the courts in 98, 99. At that time, I was working for NebHelp, which is now Nelnet, I believe. They were very lenient with me. They used to let me come and go as I pleased. So I started interpreting because I don't know how the courts found out that I was bilingual. So they called and said, "Can you come help us out?" I said, "I don't know anything about court language." I don't know that I can, but I'll come look. So when I went to the Lancaster County Court, there was an old gentleman who had been interpreting for many years. He kind of took me under his wing, got a bunch of dictionaries boned up on stuff, and I started interpreting. In 2000, Nebraska formalized the certification process. And I actually didn't pass that exam until 2007. It is a very difficult exam, and it should be, right? People's lives could be at stake. Some of my colleagues were certified earlier than that. They've been working there for a while. So I was working as a registered interpreter at the time. In 2007, when I passed the exam, Lancaster County was looking for an in-house interpreter and coordinator. So I applied for that and got that job, and I did that until 2017. At that time, we used over 41 languages in the courts across Nebraska. Pretty diverse state, actually. When I decided to go freelance in 2017, just for family reasons, moved to Seward, Nebraska. I live outside of Seward, and I regularly cover about 7 different counties that I travel to, with the expense on, wear and tear on your car, self-employment taxes. The harder you work, the more they seem to take from you. I'm a taxpayer, so I'm not here to propose that you raise this on the backs of taxpayers. I am a taxpayer. I do believe that we need this raise. We haven't had any new interpreters in 7 years. It's not an easy job. Not just anybody can walk in and do it. You do need experience. You need to gain your experience in court. You need kind of a baptism by fire. You put in all the information into your head. When you're under stress, it comes out. And you have to practice. So it is a very important, I believe, although small cog in the wheel of justice, but it is a very important one. We are part of the rubber that hits the road. I work with judges, probation officers, and we get the job done. When I'm not there, they can't get the job done. Recently here, we've been having difficulty finding interpreters for trials. It takes at least 2 interpreters to do a trial, switching every 30 minutes to avoid fatigue. It's very difficult to do that. We've actually lost 5 interpreters, some to health, some moved out of state, some have moved on to other jobs. So we really need the help. I think a better pay will go a long way to attract the talent that we need. I know that being a rural state, we are compared to the rural states around us and say, well, we're paying better than they are. But the truth of the matter is, or the true factor that should determine whether you make this appropriation is, how do we attract the talent that we need to do a good job in court? How do we provide that equality before the law? And I think that should be the factor that you consider rather than what is being paid now. $50 an hour to our minimum sounds really good. $40 an hour for travel time, and then the mileage rate at the federal rate. But the more I travel, the more I spend on my car, and repairs, and gas is kind of crazy right now. And just the wear and tear on you. I enjoy what I do. Otherwise, I wouldn't do it. I go to 7 different counties, sometimes even farther afield than that. And I wouldn't change it. I love working with judges. I love helping them administer justice. So I hope that you will support this bill. Thank you.
Thank you for your testimony. Any questions? Seeing none, thank you. Other proponents for LB 176?
Hi, everyone, members of the committee. My name is Caden Tate, Cadentait. I'm here to testify as a proponent of the the Appropriations Bill LB 176. I'm here not just as an interpreter who's been certified for almost 10 years. I'm also here as a businessman and a family man. So during my time as an interpreter, my family has grown to 4 kids, and I've had to work all that time supporting them, and my business costs have also gone up. I have a website with hosting services, payroll, taxes, professional fees, rent, and all the things that a business needs to function. Meanwhile, the wages haven't risen since I got here. And I'm kind of a test case of what's happening in the courts because during my time as an interpreter, I've gradually moved to doing less work for the state of Nebraska and more work for private companies, and also now working for the state of Colorado. I'm still a resident of the state of Nebraska, but over the past about year and a half, I got certified, or I received reciprocal certification in Colorado, and I started working more for them. And now at this point, my work comes about 30 to 40% from that state, simply because of economics. With a family of 4, my wife stays at home, we homeschool, and I need to be able to pay the bills. And even though the hourly wage might look the same or similar between here and Colorado, Colorado being 55 an hour, here being 50 an hour, the de facto pay is very different because there it's a de facto half-day, full-day rate that we're scheduled for, whereas here it's the 2-hour minimum, which is kept to in almost all cases except for trials. Because of that, my wife and I are also considering and have been considering moving to Colorado and starting a life there. It has made more and more sense for us and for me to be traveling less, taking more work for Colorado, and that'll be a great loss to the more rural counties of Nebraska, which I serve. There are only a few of us certified Spanish interpreters who are willing to travel to places sometimes hundreds of miles away, which is what I do. Living in Omaha, I travel up north all the way to the border with South Dakota and Dakota City and Iowa. I travel out west all the way to Lexington, Nebraska, which, as most of you will know, is very far away. Grand Island, out to Lincoln, and with many kids at home and a lot of needs, it just isn't feasible to be gone as much as I'm gone. But with a wage increase, it would definitely change the economic dynamics that I have to balance in my life and in my business. With that, I can take any of your questions. Thank you.
Any questions? Senator Dorn.
Thank you, Senator Clements. Thank you for coming here. So Colorado guarantees you then a half day when you're out there in court?
Not by statute, but the coordination is such that the de facto scheduling is half day, full day. So even though by statute they have an hourly rate, the scheduling is half day, full day.
Half day, full day. And when you're in Nebraska, you're working for a court system, then they only schedule you for 2 hours and it may go longer, or how does that factor?
Yeah, for the most part, unless it's a trial, which you are slated for a couple days, which also might get canceled at the last second and you don't get paid for, they try to keep to the 2-hour minimum as best as they can for economic efficiency and for efficiency of the courts. Whereas in Colorado, even though there may be a lot more idle time, they need to secure interpreters, and so they do so because the economics are such that interpreters in the districts that do have to full day rate will prefer those districts as I do.
Thank you.
Any other questions? Seeing none? Thank you, Mr. Tate.
Thank you.
Other proponents for LB 176? Welcome.
Hello. My name is Yuridia Ipokwe. It's spelled Yuridia. Ipokwe, Igbokwe. Very simple. I'm here as an advocate for the interpreters. I'm the CEO of Lingua Academy. It's a language consulting agency. I provide interpreters for mainly lawyers and nonprofit organizations, not just private sectors, not just for Spanish, but Somali, Nepali, Russian, anything that they need. And for the interpreter, the reason that I'm here is because my husband and I, we have a law office, and we mainly practice immigration and criminal, just a little bit of everything. And I was the coordinator for the interpreters. And I realized, wow, just because you're bilingual doesn't mean you're an interpreter. In fact, I call the interpreters superhero because it's what they do. It's just amazing. And I noticed that when I built the language consulting agency, a lot of the interpreters that they will go to court, they will quit because they say, well, they don't pay me enough. I mean, I'm not going to drive just for $50 an hour when they can pay me $150 an hour. And it's very clear. And but a lot of them, they do love going to court. They like the public service. They like being officer of the court. And when I go to court and I provide my own interpreters for the lawyers, and the court has their own interpreters, right? They're not the same. I noticed that they work really hard. First of all, we couldn't start the cases, and I'm sure you know, because public defender. The case doesn't start without the interpreter, and the interpreter has to come first before all the cases, and they're going to like all the floors, all over the place, in 2 languages. I only tried that once at the office, and I was so exhausted. I almost passed out and I said, I can't do this. I don't know how you guys are superheroes. And it's very, very, very sad to hear that in 18 years, it hasn't changed. These are professionals with a high level of skills. I even took the test one time thinking I can do it, and I failed. And I have taken even the ELSA and the pre-test. So this is something that requires a lot of experience. And it's something that you learn it in court. And I don't think it's fair that in 18 years it hasn't changed. And another thing is that I know it's budget, I'm a businesswoman, so I understand that part, but they're not doing 40 hours a week either. So even if you extend it to $80, it's, in my view, it's still low, but it's better than 50. And that's one of the reasons that I'm here, just to speak on behalf of the interpreters and as a Nebraska resident, that it needs to happen. It's time to happen. And that's it.
Any questions? Seeing none, thank you for your testimony. Additional proponents for LB 176.
Hello, my name is Thomas Fennell, THOMAS, FENNELL, and I just briefly want to mention something that hasn't come up. I'm also a member of the board of the Nebraska Association of Translators and Interpreters, and the chair of the advocacy committee. Speaking personally, I'm a Russian translator, and I did not go into interpreting specifically because I could make more money translating. I'm now, with the change in the Russian area, looking very strongly at interpreting. And at my age, it's a very daunting perspective to make that shift. Whereas when I came back to Nebraska in 2007, after having lived in Russia for a long time, if the rates had been higher, it would have been more attractive then. Anyhow, the thing that I want to say besides my personal story is that we have to remember that it's not just a matter of defendants' rights here and providing access to justice for defendants. It's also witness testimony, the victims of crimes, and prosecutors also need things to be translated and interpreted very accurately. The last thing anybody wants is a court overturned because of a specific piece of evidence was not interpreted and not described correctly in court. So that's all I'd like to say.
Very good. Thank you, sir. Other proponents for LB 176? Seeing none, are there opponents? Your proponent?
I was just letting the interpreters.
Okay. Welcome.
Thank you. Chairman Clements, members of the Appropriation Committee, my name is Corey Steele, Coreysteel, and I am the Nebraska State Court Administrator for the Administrative Office of the Courts and Probation. Thank you today thank you to Senator Dungan today for introducing LB 176 and for the time the committee has spent listening to all of our certified contract interpreters for the state system. I'm going to go a little off script and my testimony is here. The one thing I do want to say is it is a statutory provision in statute, Nebraska Revised Statute 25-2401. It is hereby declared to be the policy of this state that constitutional rights of persons unable to communicate the English language cannot be fully protected unless interpreters are available to assist such persons in legal proceedings. So it is a statutory obligation by us in the court system to have interpreters and to have interpreters across the whole state for all proceedings that take place. In 2011, the state of Nebraska was under a DOJ investigation for not providing high quality, high level interpretation for not only our court system, but I also want this committee to understand all probation services as well. We must provide interpretation for all probation-based services as well, to include now with the Office of Public Guardian as well. Anybody under supervision or care and custody with the state judicial branch must have interpretation if they're doing a pre-sentence investigation, supervision, classes that we perform, all of those functions that we do with probation, also with the interactions with Public Guardian with their wards, if they have somebody that is a non-English speaker or needs interpretation through sign, we must provide those services. In your packet, I've handed out, you've heard testimony to the Language Access Program. After that DOJ investigation in 2011, we created the Language Access Program, which really refined and honed what we do in Nebraska. As you heard Mr. Escobar testify to, that he started, there were really no standards. He came, somebody in the court system kind of helped him through that. We created a commission that really set the standards for what interpretation consists of for the judicial branch. It talks about the statutes that are there, the program overview, the priorities, and what have you. The second handout that I have for you is, and there has been a lot of questions from this committee regarding the rates and what the current rates are for our interpreters. So you will see there's three different rates structures for us currently: certified, provisionally certified, and non-certified interpreters. And those rates are there as well. You've also heard testimony about we have some non-certified interpreters and the provisionally or certified interpreters. That exam is difficult. It's a national exam that National Center for State Courts has instituted, and we have taken that exam, and that's the exam that pretty much all states use to certify, particularly Spanish. They're coming up and creating other languages, but at this time it's predominantly in Spanish that we get that certification in. And then those rates that go with that. One thing that we have done is over the years, we have done this on several occasions since I've been court administrator now for 9 years, is we have done studies to see what is the going rate for interpreter services in the state court systems. Obviously, you've heard a lot about the federal system and what have you, and I'd be here to tell you too, if I could get federal rate for the work that I do, I would want that as well. We know the feds pay higher in everything that the federal government does. We know that, we understand that. But what we've done is we've taken a look at state court systems across the United States, particularly in the Midwest, and the going rate for those. I have those as well. If the committee would like me to share what the going rates are from other states, I can do that. We continue to improve the work that we do.
I think, yes, we would like that. You can provide that to us.
I have them handwritten. What I can do, if the committee would like, I could have them typed up and give them to you, or I could just on the record give you what some of those rates are for the Midwest states, and then provide a written copy.
Let's have you email those to the committee.
I can do that.
To the clerk. The
I can
clerk
do
will
that.
forward those.
Not a problem, not a problem. And so those are the things that we've continued to do with the court administrator's office. It's been 3 times since I've been the administrator that we have taken a look both nationally and Midwest at what the going rate is for interpreter services. And then also the 2 hour versus the half a day and what takes place there. So those are the things that we have done within our office as well to continue to look at what we can and can't pay based on our budgetary allotment for interpreter services. Since I have been here with the court administrator office, we started with a $500,000 budget for interpreter services. This year, we are over 1.8 million, and I know it's going to for fiscal year 2022, and I know this year will be a lot more. We're in about a 7 to 9% growth based on interpreter services across the state. We not only use certified interpreters in the state, we also have to contract for interpreters outside of the state as well and fly them in and pay for that. So that's all rolled into that interpreter services. As you heard, trials, we have to have 2 interpreters, those types of things. So I'd be happy, my time's up, I'd be happy to answer any questions any committee member may have.
Senator Dorn?
Thank you, Senator Clemens, and thank you for being here, Mr. Steele. And that was one of my questions through this whole process. We started way back when at approximately 500,000 in the budget. This year you say 1.8 or whatever. Is that based on, I mean, since the rate itself hasn't gone up, I'm assuming then that's based on volume or need?
Correct. There's been a growing need every year of interpreter services. You've heard interpreters talk about 40 some different languages across the state. A few years back, we were at 53 languages. I think this year we were 47, 48 different languages across the state. We also, with the trials, the fact that we're having to bring in more certified interpreters for different dialects, different languages is an added cost. I just approved just this past week to bring in 2 interpreters, one from Minnesota, one from California, for a trial in a court on a child custody matter. I think it was a termination of parental rights. And the family spoke a specific dialect of a specific village. And the cost of that was over $6,500 to fly them in, pay their rate, hotel, food, all of those things. So that's the growing trend that we continue to see. And we continue to see more and more in our court systems.
And I'll get back to the $50 an hour. That's been a court decision to leave it at the $50 an hour, or why, I guess, the bill here is to increase it by so much or whatever.
Correct.
So the dollars just don't allow it, or why has it over time, over these 20 years, basically, why haven't we increased it, I guess? Who makes that decision?
So it is a Supreme Court rule that has set the rates for interpreter services. And so it is not statutorily provision of what the service rate should be. And I met with Senator Dungan and we've had this discussion. He agrees that it should be statutorily a statute that says, here's what you shall pay a contractor in the judicial branch. But the Supreme Court, all 3 of those times that we've done studies, those have gone to the Supreme Court at the request of an interpreter group to assess the new rates, and the court at this point in time, based on looking at what's taking place in the Midwest, have said that at this point in time there would not be an increase.
Because we're basically meeting what the general Midwest rate is. We're meeting that, you're saying?
Correct. We're meeting it in some areas, we're exceeding it in some areas, and some areas we're a little behind.
So when does that, and I don't know what the study does, but the study now, we're hearing though from some of these that the private people are paying more. So
Correct. Private always pays more than state, Senator, you know that.
I know that, but yeah. When it gets too much that you can't find staff, I guess, that staff, you've been able to adequately staff at this point in time.
At this point in time, we are able to staff. There's always that adequate piece of where is the need for more. You also heard the stringent requirements of the exam and the course that takes place. And that sometimes as well is a barrier to getting more people certified. We have on average 10 to 15 individuals about once a year that go through the coursework and take the exam, but the exam is difficult. And it should be, as you heard, it should be, because they're interpreting in court. This is termination of parental rights. This is trials. This is all of those things, that it should be stringent so that we are holding that standard to that level, which also makes it difficult as well.
Thank you for coming and thank you for answering questions.
Absolutely, Senator.
Senator Dover?
When is the last time the study was done?
We just did the study again this fall. And those will be the numbers that I'll provide the committee in a written document.
Thank you. Senator Armendariz?
Thank you, Senator. So you said that your budget is currently 1.8 million plus.
Correct. Fiscal year 2022 was 1.8 million. It was our expenditures for interpreter services.
Would you be able to give us a breakdown of where those dollars went? Hourly wages, travel, mileage, all of
Yes.
those different items?
Yes.
Okay, I appreciate it.
I had a question. Are we talking just about district courts or also county courts involved in?
Any court proceeding, Senator. So separate juvenile courts, county courts, district courts, workers' compensation court, any court, Court of Appeals, Supreme Court, if there needed to be an interpreter, but there's not testimony, obviously, in those courts. It's attorneys that put on evidence, but it's any court that we would provide. And then any service for probation and Office of Public Guardian as well. So anybody on probation that does not speak English, there's an interpreter during their probation, during their meetings, during any coursework that they take, as far as we do cognitive behavioral groups, anything like that. If there needs to be interpreter services, excuse me, then we would provide that.
Then in county court, the state's paying for the interpreter?
We pay the state for all the courts.
For all of them, all right.
Correct.
Senator Lippincott?
Couple of questions. Number one, do interpreters also interpret, fill out forms, translate forms? Lots of paperwork goes back and forth in courtrooms. Do they do that? Also, how many vacancies do you have? How many applicants do you have? And are any of the applicants not qualified due to no criminal record? Is it misdemeanor, felonies, or any type?
Okay. Bear with me while I try to answer all three of your questions. Okay. First question was forms. We do pay for translation of forms on our website, and then in our court systems, we typically have almost all of our forms translated into Spanish. And then we're working towards other languages as we can. So we do some translation. I think some of the interpreters will tell you interpretation is different than translation. And so when you translate a form, it is a little bit different. So we do have individuals we go to for translation of forms, yes. The second is, as far as these are not employees. We do not have openings. We do not advertise, so to speak. This is not a state position. These are contracted interpreters. They are a private entity, and they are, in essence, agreeing to interpret for the court system it's not a per se where we have an individual contract with each and every interpreter, but it's not an open position. We do have 4 state positions that are interpreter coordinators in Douglas County, in Sarpy County, in Lancaster County, and in Hall County. Those 4 positions are state employees, they're employees of ours, and they're in the courthouse. They're in the courthouse. They not only coordinate, one is just a straight coordinator, where she coordinates all of Lancaster County and several other counties, the coordination of all the need for the interpreters. So the court system calls and says, we have a case, we need an interpreter in this language, and then they find the interpreter and schedule that interpreter. We have 3 others that also not only do the coordination, but then also do the interpretation within the courthouse. Not all the interpretation, but they do interpretation as well. Criminal record. So yes, so when somebody goes through the certification process, we do scrutinize criminal record. We have in the past, after somebody has gone through the process and we do a background check on interpreters, there is a background check. We've had to deny somebody based on a felony conviction of a drug offense in another state. So we have had to do that, and all interpreters have gone through that process. So we vet them as they come in. So as they go do the coursework, take the exam, before they are given that certification, there's a background check.
Thank you, sir.
Senator Armendariz?
Thank you. So the certification exam, is that public, available to the public? And if not, would you make it available to this committee?
The exam itself, I can get you an example of the exam, yes, that's taken.
Thanks.
Or you can provide that to the clerk.
Absolutely.
Any other questions? Seeing none, thank you, Mr. Steele.
Thank you very much.
Are there other proponents for LB 176? Seeing none, are there opponents regarding LB 176? Seeing none, is there anyone here in the neutral position? Seeing none, Senator Dungan, you may close.
Thank you, Chair Clemens, and thank you to the committee. I want to say thank you as well to all the testifiers that came in today. I think it's really important for everyone to hear the individual stories here. I think they've touched on a number of things that were vital for what we're talking about. I want to address a couple of the questions that came up briefly and make just a couple of more points, but I'll try to be brief. First of all, I want to highlight that this does have a specific influence and I think a benefit to rural areas. I think oftentimes we see rural areas disproportionately impacted by the lack of interpreters, especially in court circuits where you're traveling from county to county. We've talked a lot about the rates that people get paid for driving. That becomes really arduous and burdensome when you're spending more of your day in your car than you are actually in the courtroom. And so this increase in pay, I do think would have a true benefit to areas in rural or courts in rural areas. I also just want to highlight again from my personal experience, the talent that goes into this, it cannot be understated. And that's not just to say that it's difficult to interpret, but I think we often forget some of the idioms we use and how legalese works. You all, I'm sure, can tell that I talk very fast. These poor people have to keep up with that, and that's really frustrating. In addition to that, when I'm in a trial where we're talking to a client, if I say, for example, we're just going to ask for a continuance and kick this down the road a ways, that's a pretty difficult thing to interpret to make it accurate. And so those kind of things get brought up in trials and in conversations. And so I just want to highlight, again, we're talking about really niche and specific work that we're doing here. And there's actually interpreters in the room today that I didn't know were going to be here that I've worked with in court before who do simultaneous translation, which is also it's a whole different skill set where you're talking and they're talking at the same time, whispering into the client's ear, keeping up with what you're saying quickly in legalese and using idioms. And so it really is a thing that I think is we're getting what we're paying for. And I think that's really important to note. To your question, Senator Lippincott, about the forms, I think Mr. Steele did a very good job of differentiating interpreters from translators. But again, in the courtrooms, it can get pretty crazy. There's oftentimes motions that I have to have a client sign that I'm walking out in the hallway and reading it to the client through an interpreter, and they have to keep up with that and then answer questions through the interpreter as the client signing the motion in the hallway or something like that. So even though they're not necessarily translating the form, they are having to interpret what's in the form and sort of get across the message of that. So that's important, I think, too. I also specifically want to thank Mr. Steele for being here. One of the things that he mentioned that I think is important to note, we're not talking about statutorily setting a rate. We've heard a lot about $50 an hour, $80 an hour. I believe there absolutely should be an increase. And in the conversations I've had, both with the courts as well as the interpreters, we kind of know what those rates are going to look like. But we're not asking the committee here to pass a bill that says thou shalt pay X amount for the interpreters. The court's obviously done a lot of work and a lot of studies to figure out what those rates would be. All we're asking for is that appropriation to go to the Supreme Court. And one last clarification, and I think this is to your question, Chair Clemens, it's not just to the Supreme Court for interpretation. They're just the office that runs all of the different services. And so, again, I think Mr. Steele did a fantastic job of outlining the different services that these interpreters go to. It's all levels. So happy to answer any additional questions, but I think it's very vital that we work on this now to make sure that we keep these interpreters. As we've heard, we're losing them, and I think we're going to be at a crisis point soon if we don't try to keep people working with our interpreter services. So thank you for your consideration.
Senator.
Thank you, Senator Clemens, and thank you, Senator Dungan, for being here. I should ask Corey Steele when he was here. Are they ever allowed to do, I call it now, we have in some of the court systems, they have I call it the or the Zoom type meeting, or interpreters are allowed to do that, or, okay, he's shaking his head.
Yes. And so obviously courts changed a lot during the pandemic, and we shifted to sort of a hybrid model for quite some time where you're doing Zoom court, interpreters are logging on there. That's made it easier, I know, for certain rare dialects, for example, to be utilized. I could go into great detail about the time I did a 2-day-long hearing with Romanian interpreters via phone because we couldn't find any in the state, and that was a whole ordeal. Yeah, they do work through Zoom, but it's always better to have people there in person. I think, when we're dealing with these intricate things, talking about legalese, idioms, and I think like Mr. Escobar highlighted, we're talking about people's lives and really serious circumstances. So they try to be there in person, but yes, they can utilize teleservices if need to.
Any other questions? Seeing none? Thank you, Senator.
Thank you,
Dungan.
Chair Clements.
We have position comments for LB 176. We have 23 proponents, no opponents, no neutral.
Thank you.
That concludes LB 176. We will move on to LB 508. Senator Conrad. Welcome, Senator.
Hello, good afternoon, friends. My name is Danielle Conrad. It's Jnielle, Conrad, Conrad. I'm here today representing the Fightin' 46th Legislative District of North Lincoln. And it's a pleasure to be back in front of the Appropriations Committee. But my goodness, the setting has changed a bit in this temporary assignment that you have. You have a little bit more elbow room, though, so maybe that's not a bad thing. But I'm pleased today to introduce LB 508. And what this measure would do is it would appropriate $2 million over 2 fiscal years to the Supreme Court for the Office of Dispute Resolution to support and increase funding to the Supreme Court for approved mediation centers. So I wanted to provide just a quick background for how I got the idea for this legislation. So last summer, I attended a CLE, a continuing legal education course that the Bar Association put on in Lincoln. It was called Lawyers and Leaders. And in the afternoon session, they had a very well-attended learning opportunity with many judges from different levels, county, district, and Supreme Court judges there with a lot of stakeholders in the legal community. And they were talking about caseloads, and they were talking about access and administration to justice. And we were talking about problem-solving courts and other sort of mechanisms that our state had available to, ensure access to justice for our citizens and to balance judicial resources and efficiency. And one of the issues that popped up was, from the judge's perspective, and I'm kind of generalizing or paraphrasing here, was just how valuable the mediation centers were across the state for family law issues, for juvenile justice issues, for small claims court issues, things of that nature, and how that really helped citizens to get good outcomes for the legal issues they were facing, and how it helped to reduce the court caseloads in some regards, or streamline or refine issues before it got to the court for final disposition. So it was just a very compelling discussion, and it really stayed in my head and in my heart. And after the election, I reached out to the Supreme Court and just said, hey, I attended this great learning opportunity. This issue popped up. It seemed to have great resonance across the political spectrum, across the state. Is there anything that we can do to try and get some more resources to our existing mediation centers now that we have a little bit of breathing room from a fiscal perspective? And so Corey Steele and the Supreme Court and their team were really generous in helping me to take that kind of general idea and put it together in terms of kind of a plan that would best meet their needs to expand, to maintain and then expand services. So that's how the bill came together. And just so that you know, this the Office of Dispute Resolution, and I passed out 2 materials. One, just kind of general bullets and talking points. The other is more of a 2 or 3 page article from a recent Bar Association magazine that kind of details the history of the mediation centers and alternative dispute resolution issues in Nebraska. So this structure has really been on the books since the early 90s. Actually, my predecessor, Senator Landis, helped to bring forward the legislation that helped to provide the initial infrastructure for the mediation centers across Nebraska. And it's a really smart system. Nebraska is not the only state that has a system like this in place. I think we're one of about a handful of states that have a system like this in place. But what we have seen is that the need for these services has really outpaced the funding that they have available through a variety of different revenue streams. And it's also important to know that they don't turn anybody away because of a lack of ability to pay. So I just wanted to kind of put this history before you, let you know that they provide services in really every corner of Nebraska, and it really is, I think, related to the core function of the judiciary and helps to address a lot of real life issues that are facing Nebraskans, whether it's, you know, coming up with those parenting plans when people are going through a dissolution, or whether it's dealing with juvenile justice issues for young offenders and maybe helping them get set on the right track with restorative practices, or those small claims kind of issues that pop up too. Those are, I think, some of the biggest issues that pop up, but they really provide a lot of different services. So happy to answer questions. Also happy to defer to the experts behind me. Yes.
Senator Armendariz.
Hi.
Hi.
Thank you, Senator. Thanks for being
Yes,
here, Senator. What is the current budget for this?
Yeah.
And I can follow that up while you're looking, but
Sure.
What do they expect to accomplish with an additional $1 million?
Yes, I don't know exactly what their current budget is, but hopefully some folks behind me might know. And if not, I can look it up in the meantime before the closing. But I know that their thinking was they have about, I think, $45,000 or so to speak under kind of their existing revenue streams or structures for each of the 6 centers. So they were thinking the additional $1 million would provide $150,000 instead of $45,000 to each of those 6 centers, and then it would have about $100,000 for administration and mediation training, kind of at the umbrella, kind of at the top lines for it for each of the centers. If that's helpful.
Yeah. So
Yeah.
is there? I'm sorry.
Yeah.
Is there like a big waiting list or a set amount of court cases that could go to this instead, that they have calculated and kind of given the numbers behind the support for the ask, that we could be seeing so many more?
I think that's exactly right. So if you look at the little bullet point sheet that I handed out, you can see that, like, for example, back in fiscal year 2003, their case volume was at about 1,200 cases. And then this last year, they were up to 4,300 cases. And so I think that what we're seeing is a real significant and fast rise in terms of the number of cases that they're dealing with there. Now, they do get, some resources from filing fees and from state appropriations otherwise. But when I opened this conversation with the court, Senator Armendariz, I asked them what would be the right number and what would be the right way to structure the appropriation request to do the most good. Because I was just thinking, I don't know, $1 million per center or something like that to maybe help get an infusion of cash to help them train more people or deal with backlog or maintain their existing good work. And they went back to all of the centers and they said, we feel like this would be the best way to structure an ask to do the most good based on our caseloads and our needs. So that's kind of how we got to that number, was based on feedback from the centers.
And one more question.
Yes.
How much money do you expect to save moving those to a mediation center as opposed to a court?
Yeah, that's a good question. I mean, I don't think that we will be in the business of winding down any court operations anytime soon. In fact, I think we'll probably continue to see an expansion thereof. For example, you might see that Senator Aguilar actually has a bill on the agenda about growing the footprint in his area for some more judicial resources. But I don't think we'll probably be saving any amount in terms of judicial resources that we can see a budget reduction or a staff reduction in the existing judicial kind of structure. But what I do think we'll see by making this advanced investment and expansion is just those cases will receive, I think, more attention and better outcomes before they're just kind of dumped into the court system, so to speak. By having more resources with the mediation centers, it helps to resolve some of those preliminary issues. It helps to identify potential alternatives. It just takes a little pressure off the court system and makes it work a little bit better. So is that helpful? Okay. I don't think you'll see a projected cost savings though on the other side of the ledger with this kind of increase.
Any other questions? Seeing none?
Okay, well, very good.
Other proponents.
And just so you know, I'm running back and forth to judiciary because I have another measure up there too, but happy to answer more questions and continue the dialogue as well.
Thank you, Senator Conrad. First proponent then for LB 508. Welcome.
Thank you. Good afternoon, Chairman Clements and members of the Appropriations Committee. My name is Kelly Riley, Kelley-Riley. I'm the Director of the Office of Dispute Resolution for the Administrative Office of the Courts and Probation, testifying in support of LB 508. First, I want to share a little bit about the Nebraska mediation system. The Dispute Resolution Act created a public-private partnership with nonprofit organizations to provide statewide mediation services. This is an extremely efficient and effective delivery model that allows all Nebraskans access to mediation and restorative justice services. The Office of Dispute Resolution and the Supreme Court's Dispute Resolution Advisory Council provide oversight of the 6 mediation centers and conduct financial and programmatic reviews as part of each center's annual approval process. One of the handouts provided is a roster of the centers. There are 2 centers that serve the 3 most populous counties. The remaining 90 counties and 4 tribal nations are served by 4 centers. Access to mediation is a priority. To reduce barriers to access, centers travel to where the parties are and have implemented a virtual option to improve access for rural and urban Nebraskans. On the second handout, you'll see that every year the centers provide mediation and restorative justice services in most counties. The Dispute Resolution Act requires the Office of Dispute Resolution to award grants to approved centers on an annual basis. Since fiscal year 2005, the grant has been $45,000 per center, a total of $270,000. The annual grant was made possible through a cash fund that receives revenues generated from a 75-cent court filing fee. In August 2021, the centers were notified that the annual grant was in jeopardy due to the cash fund's decreasing balance. Every year since fiscal year 14, court filing fees have been less than the grant disbursement. A graph showing the cash fund's revenue and grant expenditure history is included in the handouts. In 2021, the funding shortfall was brought to the attention of the Appropriations Committee. Thankfully, during last year's legislative session, the committee appropriated $270,000 to allow for the continuation of the annual grant at the same amount, which is allowing the dispute resolution cash fund to replenish. Reducing the grant funds to the centers would have been devastating, as they would have needed to reduce staffing and services. The purpose of the grant funds is twofold. One is to subsidize cases that are low fee or no fee. Per statute 252910, approved centers cannot deny service to anyone due to an inability to pay. Secondly, it helps the centers keep their doors open. Without the centers, the judicial branch and the Office of Dispute Resolution cannot meet our statutory obligations. While the centers still receive the same level of grant funding today as in fiscal year 2005, it's important to note that the centers handle a lot more cases. The handouts include a graph showing the growth in annual case volume. The increase in cases is a direct result of the number of services now available through the centers. In addition to providing mediation for community-based conflicts and parents living in separate homes, the centers are trained to provide a safe process to parents when there is intimate partner abuse. They mediate small claims cases and neither party pays a fee. They are mediating more landlord-tenant cases. The centers are working with students, their families, and school personnel to address school absenteeism. They're providing juvenile restorative justice when appropriate from various referral points: schools, county attorneys, diversion offices, courts, and probation. The centers also facilitate child welfare cases, allowing families to have a greater voice in working towards reunification, and facilitating conversations when reunification isn't in the child's best interest. Elder mediation is another area of focus for the centers. The reason I'm pointing out all these different case types is that proposed funding in LB 508 will support the center's continued mission to provide and potentially expand their services. For example, upstream juvenile restorative justice cases are currently funded through a $1 million 3-year federal grant awarded to the Administrative Office of the Courts. Financial sustainability is a looming concern when the grant ends. Funding is necessary and beneficial to the state as restorative justice programs through the centers can keep youth from becoming court system involved, and for other youth may reduce their time within the court system. In summary, the approved centers are a valuable resource to Nebraskans who want to be more involved in the outcome of whatever they may be dealing with. Please note that mediation and restorative justice never takes away a person's access to the courts nor their legal rights. Thank you for this opportunity to provide information in support of LB 508. I encourage you to vote the bill out of committee, and if you have any questions, I'd be happy to answer those.
Are there any questions? Have you requested an increase of the court fee?
So last year, I think that was a conversation, but I don't know that we made that specific request, but that was a conversation we had with Senator Stinner last year.
That's set by appropriations.
The court filing fee, I think that goes through the Judiciary Committee. That would be a Corey question, so.
All right, we'll talk to Corey about that. Seeing no more questions, thank you for your testimony.
Thank you.
Are there other proponents for LB 508?
Good afternoon, Chairman Clement and members of the Appropriation Committee. My name is Michelle Luders, Michele Lueders. I am here today in my position as the Executive Director for the Nebraska Mediation Center located in Fremont, Nebraska. I am also representing the other 3 rural mediation centers across Nebraska, and today I'm here to testify in support of LB 508. As you've heard previously through Senator Conrad and Kelly Riley, the mediation centers in Nebraska provide a continuum of services that span across all 93 counties, including the 4 tribal nations. The mediation centers provide individuals an opportunity to work through conflict and repair their relationships. And mediation also allows a neutral third party to facilitate these conversations in areas that are identified by the parties participating in the mediation. Rural Nebraska continues to see a reduction in service availability, which also includes having attorneys available in all counties. Mediation centers can assist individuals in developing potential solutions or resolving their conflict prior to court action. But please note that mediation services do not replace legal representation. I just want to share a little bit of information about the 4 rural centers for your information. The Nebraska Mediation Center, like I said previously, is in Fremont, Nebraska. We cover 24 counties as well as the 4 tribal nations in northeast and north central Nebraska. Our center serves 14% of the state population that covers over 22,000 square miles, which is approximately 29% of the land space here in Nebraska. The Resolution Center is located in Beatrice, Nebraska. They cover 16 counties in southeast Nebraska, which encompasses more than 9,000 square miles. In the past, the Resolution Center has seen a 58% increase in their caseload since 2003. Going into Central Mediation Center in Kearney, Nebraska, they provide services to 35 counties in central Nebraska, covering over 27,000 square miles, or 35% of the land space here in Nebraska. The population in Central Mediation Center's 35 counties is 318,542 individuals, which is about 16.24% of Nebraska's total population. When we go to Mediation West in Scotts Bluff, they provide services to 15 counties in western Nebraska. This makes up nearly 23% of the land area in the state, but is home to less than 5% of Nebraska's overall state population. Additionally, 14% of those individuals in the western part of Nebraska. They live below the poverty level compared to the Nebraska average of 11%. These factors present unique challenges to the mediation centers. These factors present unique challenges as mediation centers continue to strive to meet the state mandate in making mediation services available to all residents in all 93 counties. Stabilization of funding is critical to ensure mediation services are not relegated to urban-only centers. To ensure individuals have access to services, centers travel to where parties are located. Our mediation centers continue to offer both a virtual and a hybrid version, so we can meet the clients where their needs are. And with the video conferencing, this has been able to reduce some barriers to ensure services are available across the state. In summary, this funding would significantly support all of Nebraskans. This includes our local communities, counties, other system stakeholders who use mediation services. Mediation is a cost-effective way to empower individuals in conflict and observe them discovering an outcome that is unique and mutually beneficial to their specific situation. I appreciate this opportunity to speak with you today. I encourage you to vote this out of committee, and I'd be happy to answer any questions.
Are there any questions from the committee? Seeing none, thank you for your testimony.
Thank you.
Additional proponents for LB 508.
Good afternoon.
Welcome.
Senator Clements and members of the Appropriations Committee. I'm Casey Cargus, C-A-S-E-Y, last name Cargus, K-A-R-G-E-S. I'm the Executive Director of the Mediation Center here in Lincoln. Been here since '07. Also representing Omaha, the Concord Center, and Dan Bechtel. We kind of divided into rural and urban for our testimony today. Two kids get in a fight in school. A ticket gets written and it goes to the county attorney. You have options from that point forward. What if kids came to the mediation center? We provided an opportunity for them to get together and work out what went wrong. Could they say they're sorry? Could they pay something back? A way to work themselves back into school. Two friends living together decide not to live together anymore. They fight over how they divide up their stuff. We have options. In Nebraska, that can get really ugly, or they go to small claims court. Lancaster County 15 years ago, judges weren't sure about mediation. Today, about any case that comes there, they want to see if they can get together there the day of court, if they can work something out. Hear one another, come up with options they probably couldn't do in court to see if they could resolve it in that way. A kid gets removed from the home. They're struggling within the system of what are they going to do next. They come to a mediation center, we bring everybody in. We bring family members in and caseworkers in, attorneys in. And what we try to do is we try to in some way listen to what the family thinks they can do to provide safety for those kids. And then it's the family plan that goes back to the judge, because the odds are if the family in some way agrees to it, the odds of them living out are just a lot better. It was 30 years ago over the farm crisis that all this got started here. And in some way, it has just exploded. Where today I was working with a group like this 15, 20 years ago, and in some way they were trying to decide, can a case get ordered to mediation? Today, about every case before a judge wants to hear it, wants to see an attempt at it. And so we work with Office of Dispute Resolution, District Court, County Court, Probation, Diversion, local counties, schools, special education. All these opportunities in some way can we work on the resolution before the case has to keep going. I use an example, just FYI, Nebraska is a leader when it comes to mediation. This body, the bodies of the court, the bodies that lead this in some way, we had a huge study that was done actually out of Canada on Nebraska. And being from Lancaster County, what got me is we do a specialized way to work with all families, even in high conflict domestic violence cases. We can figure out safe places for that to happen. In that study, 93% of all cases in Lancaster County that had a custody issue came to a resolution before a judge had to rule, which is remarkable. Through mediation, through attorneys, through them working together, most of the time, we can figure that stuff out. What's different in Nebraska is it's not like one's going to win over the other and you're never going to see them again. We're going to work with these people. We're trying to create processes where in some way people can handle conflict better. And so through this, what we've discovered from when this first was passed and we had the 45,000 today, it's over a 300% increase in cases. It's working, and it's working great. And we want to continue to provide opportunities for mediation in all these different areas, and we have places to go. Lancaster County is doing an incredible job when kids get in trouble. We're doing these, we're working brand new in the past couple of years. We're starting to get into truancy. Can we get families and kids together to work out? Can they come up with a plan so they can go to the schools, and then we can work with the support for them to do all of that. So what we're trying to do is it has worked. We cannot turn anyone away with the inability to pay, which is with the increase in cases. Let me go back to what we're doing. It's working, and we want to continue to find new ways for mediation, Nebraska to be a leader in the mediation field. Thank you for the opportunity. I hope you support 508. Any questions you have?
Questions? Senator Lippincott?
Your paper that you hand out, it said that 93% of the cases have been resolved before it gets to the
In
judges.
those family cases, yes.
Yep. What percent of those has your mechanism helped with?
Yeah, great question. What I would say, I'll use Lancaster County example. We open up 500 to 600 mediation cases just at our center in Lancaster County, and there's probably 1,700 filings in our county. So we deal with probably a third of those. Now, let me say this. They're incredible private mediators. We have great mediators. A lot of them are affiliated with us. And some people resolve on their own, which is really positive. But we touch probably a third of those in Lancaster County.
Additionally, your caseload has gone up 355%.
Yep.
Like you say here in your paper. And each center gets about $45,000 per year.
Yep.
So with that increase, how much are you going over that $45,000 per center?
Oh, we're doing an awful lot. And the model is working, meaning we go after grants to start new programs, to sustain ourselves. We get filing fees. For example, would be parents. When parents come in, we work off a sliding fee scale. And we probably go through our 45,000 in 6 months period of time for what we can justify. And so, and what's exciting is new thing is coming up. The stuff we're doing with schools, 5 years ago, we weren't doing any of those. Right now at just our center, we're opening up probably 200 cases a year for kids who get in conflict in schools. And so to develop those, you just have to start and make it happen. And there's other areas we're just starting to get into the elder issues. Families in conflict with grandma, grandpa, and are they needing to go into a home, or kids are fighting, or there's just areas that I think mediation would be great to lessen the conflict. A lot less time them, getting into court. We're trying to see if those can be opportunities for people, and we want it available across the state. And for even those people that can't afford, we want to use that sliding fee scale.
So you're saying by July 1st, you burned through $45,000?
Oh, yeah, for the number of cases that we, yeah.
So you approximately go through $100,000 a year, is that right?
Oh, yep. Yeah, and there's always the next new thing. The elder thing is the next new thing. So we start pilots, we come in, we work together. Probation, we've done the same thing. That takes a lot of time to come up with those new, and just FYI, we have a small staff. We have 5 on staff. We have a couple of attorneys. In our center, we have 100 mediators that come in and mediate for us. People like you that come in with specialized areas of interest. So we have the ability to grow. People want to do conflict better. So we can justify the 45,000 with the growth that we have seen in all these different areas. We can justify easily in the first 6 months, but we always want to get into a new areas. There's always more opportunities, I think, for mediation.
This question was asked earlier and didn't get an answer on it, but obviously we want to do this rather than going through the full-blown court system. Each divorce, I've read, this is dated somewhat, but each divorce case costs the government approximately $30,000. It's expensive.
Yeah.
Doing it this way is less, but you can't really give us a concrete number how much money is being saved going this route versus.
That is a great question. I've never seen that number. I would say Lancaster County would be less than, people that come to us. But what's exciting to me with the whole mediation stuff is people are realizing that they can work, they're parents, and if they can work together to figure this stuff out when it's over with, they didn't bury one another. And so I think there's the financial cost, there's the stress cost, and I think it's making a difference.
Other questions? Senator DeBoer?
As far as working with, youth or along those lines, I could assume I don't want to do that, but I'm guessing there could be a benefit of learning how to have a resolution and perhaps mature them, which be a little more mature, and as opposed to feeling like the judge did this to them and life's not fair.
Yeah, it's really cool. We had a program that started out at Lincoln High because of the racial tension that was happening. We had a bunch of kids come to us and they were worried about the conflict that was happening in those schools. So we had one of our center directors work with their principal, and they had this group of girls from different countries that created a peer-to-peer mediation. So when the tension started, they could get people together to try to resolve it before. Well, those kids are now being surrogates in our restorative justice program. When other kids get in schools, a lot of times we put a kid who's been through the program in the room. They've been through it, they've seen it, they know what the kids are talking about. The kids relate a lot better to someone younger than me. So we have these pool of kids who are going through these processes. And Lincoln Public is trying more and more to put restorative justice into their starting classes. We're working with them and trying to have better ways to have this stuff happen. So this stuff is bubbling. It's exciting. I think it's really good stuff.
Seeing no other questions, thank you for your testimony.
Thank you.
Are there other proponents for LB 508? Welcome, Mr. Steele.
Chairman Clemens, members of the Appropriations Committee, I was pulled up today by Chairman Clemens and his question to clarify. I wasn't planning on testifying as Kelly Riley did based as our director of ODR. And I want to add a few things to Casey's testimony. Senator Clemens, there was an adjustment in, I want to say 2016, 2017. I'll get that specific bill that we had asked for a court fee increase, but it was particular. It was during child custody. And so the mediation centers started seeing child custody coming to them, that parents were not married, and statute was specific to a divorce proceeding and child custody. And knowing that now close to half of our population that is not married are having children and cohabitating and what have you, we made an adjustment to that statute that said during any child custody proceeding. So not just a divorce child custody proceeding, because we knew that the divorce wasn't having to take place. And there was a fee, a court fee that then came to our office for the mediation process to set up the parenting plan and all of the work that the mediation centers have done. So we did ask for a court fee increase at that point in time because we were seeing that specific. We have several different funds that fund the mediation centers. The $45,000 is one, but there are also some other court fees. And as Casey said, it's really pooled funding and how they operate. It's the pass-through that we get, the $45,000 that goes to each of the centers. They also do some HHS work that the funds did go to HHS. We made an amendment, and now those funds directly come to us, and we pay for them out of those pooled funds as well. And then I believe it was 2 years ago, Senator Clemens, we worked with Senator Stinner at the time to get a $270,000 direct appropriation to the Office of Dispute Resolution. It was discussed, should we go for a court fee increase or should we have a direct appropriation? And at the time, it was felt that a court fee increase would not be adopted by the body and it would be a better way to go. So it was a sustainable $270,000 that would come to our budget to then divvy out to the mediation centers. What that's going to allow us to do is hopefully the 45,000, as soon as we build that cash fund up, because it is a cash fund that it goes into, then we can start doing a 3%, 5% each year increase on the 45,000. So it does go up because we see the increase and the great work that they're doing, and the need for additional sources. So there's a lot of funding that goes into the mediation centers, whether it's families come in and privately pay or an individual privately pay, sliding fee, grants, as Casey talked about. They do a lot of grants and we assist with a lot of grants, and then also this funding that comes through the state. So I did want to clarify that. There were two different in my time that we've made adjustments. One was a statutory adjustment for all child custody and family plans to pay the court fee instead of just divorce proceedings. And then the second was the $270,000 direct appropriations.
Very good. Any other questions? Seeing none, thank you, Mr.
Thank you.
Oh, Mr. Steele, would you spell your name for the record?
Oh, I'm sorry. Coreysteel.
Thank you. Any other proponents for LB 508? Seeing none, are there any opponents on LB 508? Seeing none, anyone here in the neutral position? Seeing none, we have position comments for LB 508. We have 10 proponents, no opponents, no neutral. That concludes the hearing for LB 508, and we will move to LB 761. Senator DeBoer, welcome.
Thank you so much, Senator Clements. This is my first time here in Appropriations, and maybe I think I've only ever once been before Appropriations, so I feel a little nervous. Hello, good afternoon, Chair Clements and members of the Appropriations Committee. My name is Wendy DeBoer, WENDY-DEB-OER. I represent District 10 in Northwest Omaha, and I'm here today to introduce LB 761. LB 761 requests more funding to the Office of Public Guardian, or OPG, for staffing purposes. On Tuesday, we heard from the Chief Justice in his State of the Judiciary about the OPG. But as a reminder, the OPG provides guardianships and conservatorships for individuals that have been deemed by a county court to be incapacitated and that have no other individual who can serve as their guardian. Individuals who are under guardianship can suffer from mental illness, dementia, chronic debilitating physical ailments, or have developmental disabilities. Once referred for public guardianship, the OPG works to place them with a guardian. A guardian is the decision maker for the ward under their care, both for financial and medical decisions. The OPG by statute is required to have a caseload of no more than 20 wards per one associate public guardian across the entire office. When the office is at that capacity, any new referrals for the OPG services end up on a wait list developed and maintained by the OPG. In 2022, 96 individuals who were referred to the OPG were placed on the wait list. But I'm told that judges actually know how long and almost hopeless this wait list is, so that they don't even refer folks to the list anymore because it is so long. So that number is actually much higher than the number of people on the wait list is actually much higher than what we can see there. While waiting for a guardian to be appointed, then these individuals wait and wait. In some cases, this has meant individuals staying in a hospital bed for more than a year, waiting for a guardian to be appointed before they can be moved to an appropriate facility for their needs. To highlight the difficulties faced by our guardians, I would encourage all members of this committee to read the Office of Public Guardian's annual report
On page 12 to 15 of the 2022 report, the OPG highlights 4 individuals, their stories, and the struggles faced by the OPG while assisting those individuals. It's quite illuminating to the difficult degree of work faced by our public guardians and the need of those individuals who wait for guardians. Associate public guardians serve in 7 districts across the state. And as the committee can imagine, there are some difficulties facing the OPG in filling these important positions in some areas of our state. My understanding is that folks working in other areas will help to try to fill in the gaps for those in those areas so that the actual numbers we're lacking in each area varies, but ultimately we simply need more guardians. In 2022, judicial branch funds were repurposed to add more openings because everyone recognizes how important it is to support this office, but it was obviously just a start. The need for guardians continues, and we are woefully understaffed for the need that we have. Simply, more public guardians means more individuals taken off the wait list, and we have too many Nebraskans on that list. And that's why I brought LB 761. We have to support the Office of Public Guardian in their work to adequately serve the needs of Nebraskans. In this bill, I've requested $700,000 for the Office of Public Guardian for staffing. And that number didn't come out of thin air. Over the summer, I asked State Court Administrator Corey Steele how much it would cost to hire 4 more public guardians. So 4 more public guardians at a case ratio of 20-1 would mean 80 more individuals off of the wait list. Of course, that doesn't get us through our wait list, and certainly doesn't if all of the people that should be on the wait list were there. Mr. Steele said in order to hire 4 new associate public guardians plus the necessary support staff, it would be approximately $700,000. The breakout works out to be 4 associate public guardians at a total of approximately $390,000, 1 case reviewer at approximately $101,000, and 2 administrative aides at approximately $167,000. Michelle Chafee of the Office of Public Guardian will be testifying behind me and can speak to more specifics of their work to increase staff levels and how LB 761 would aid in that effort. She can also probably speak to the ratios of staffing public guardians to support staff. One more thing I want to leave you with is the downstream impacts of individuals sitting and waiting for a public guardian and how it affects all Nebraskans, specifically with regard to our hospitals. When an individual is admitted to the hospital with no payer source, no ability to enroll in a payer source, and no one who can make permanent decisions, placement decisions for them, they continue to occupy a bed in the hospital. And regardless of the length of stay, hospitals are only reimbursed by Medicaid on a diagnosis rate system. So that means if an individual was admitted for a procedure that only should require a 3-day stay, the hospital only receives funding for those 3 days, no matter how long they may stay in the hospital. So individuals sitting and waiting for a guardian means a financial and occupancy strain on the hospital, fewer beds and higher costs for your average Nebraskan. It also means individuals who need the highest levels of specialized and comprehensive care found in our major hospital systems may not be able to be transferred to that hospital because there simply isn't room for them. We need public guardians to help those who cannot help themselves, to provide support for those individuals, and to be sure they are living in an environment that is best suited to their needs. Lack of guardians affects our hospital capacity, the cost of healthcare, but more importantly to me, the lack of guardians leads to worse outcomes for these patients, a worse quality of life. Fully supporting the OPG so that we can get folks to the correct level of care is an ultimate cost savings for our state and leads to better outcomes for folks who shouldn't have to live out the rest of their lives in a hospital bed because there is no one to do their paperwork. Thank you, and I'll answer any questions if you have any.
Senator Armendariz.
Thank you, Senator Clemens. Thanks, Senator DeBoer, for being here. Since you brought this up, you might not be the right person to answer, and maybe the person behind you can, but when you talk about hospital stays. So if somebody is admitted with no payer and say they have a procedure done that would be a 5-day hospital stay, and they stay in the hospital for up to a year waiting for somebody, or in some cases, is it because the hospital cannot release them without that guardian?
That's correct.
Or,
So
and then who picks up that cost if Medicaid
The
only
hospital.
pays for the $5
the hospital,
or the 5 day?
the
So
hospital.
the hospital is now responsible for treating that patient at no
Yeah.
cost
Right.
to the patient or anybody else.
Right. I mean, if the patient had any money, but typically these folks don't have the money to cover that. They don't
Okay.
have insurance.
So
they don't-
possibly the hospital is going to bill them, go to collection.
Something like that, maybe something like that would be there. And someone else can tell you how often that happens, what percentage
That was my next
they're gonna
question.
recover.
Could you get me the numbers over the past year of how many people languish in the hospital unnecessarily? And for how many days that totals? This may give us a better understanding budgetarily why this would be a better plan than that. But if you're saying the state doesn't pay for it, maybe, the numbers don't play out. So what I'm trying to do is balance, if the state's paying for them to be in the hospital unnecessarily, this might be a lower cost to the state to fund this instead.
It may be a lower cost to the state in terms of a direct cost balance. Like the state doesn't have to pay any Medicaid if they're not enrolled in Medicaid, although they should be enrolled in Medicaid because then the hospital is covering the cost. But I think there's probably some indirect costs that get worked out if the hospitals have to pay for it. So I can get you those numbers.
Okay.
And/or someone else can probably have them behind me that might have those as
Because
well.
what you're saying is, if they're on Medicaid, Medicaid pays for the procedure they get admitted to the hospital for in the first place, but then they stop once they say it's been a long enough time, they should be released. Hospital doesn't have anybody to release them to.
Correct.
So now the hospital is on the hook.
That is what I'm
for
saying.
providing care.
Yeah, that is what I'm saying, and that is what is most of the time the situation with our folks who need a guardian, is that they don't have a payer. I have another bill in judiciary. I have sort of several bills along this problem because this is a problem I feel we need to address. I have another bill in judiciary that would create, it's maybe a work in progress, I will admit, but create a temporary public guardian that would allow them just to be the public guardian for purposes of getting the paperwork filled out to get them onto public assistance. And then the placement, maybe that too, we're still working on negotiating and all of that. But then there would be additional, guardianship duties that they'd be on a wait list for. There are some strong feelings about that bill as well. So I don't see this as, I'm not just asking you to do this and then I'm going to wash my hands of the problem. I don't think we just throw money at the problem and it's fixed. I think there are a number of things we need to do. But honestly, if we had enough guardians, it kind of gets away from having any other problems, right? If people can get to, it's literally someone just can't fill out the paperwork. If someone can sign for them and can watch out for them and make sure they're getting to the right place and not the wrong place, then we don't have people waiting in hospitals that don't need to be in hospitals. And I probably don't have to tell you that someone who's in a hospital that doesn't need to be in a hospital is having a reduced quality of life.
And can I ask one more question?
Yes, quickly.
Sorry. So does this solve the problem of the nursing home placement shortage, though, that they would need to be transferred to in some cases?
If they're going to a nursing home, no, I mean, that's another issue.
Okay, thanks.
Excuse me, Senator Burgess.
I missed part of the opening, but I did want to thank you for introducing legislation. Not a lot of people know this, but one of my wife's first jobs was in Office of Public Guardian. And, she's a public defender and she now works with, children and families across the state. But this is, it is a very inherent need. And it is one of these professions that if you have not, and I say this professions in terms of a state agency, if you've never had to deal with what the intricacies of the work of public guardians, as you were describing, it's really hard to understand what the need is. But once you see it, and I've seen it firsthand from my wife, you're like, thank God there's somebody that is doing this work, and it's under public oversight of our state.
Yeah, the reason the creation of the public guardian, the Chief Justice mentioned this the other day, is because
there was a lawyer who was basically defrauding a bunch of people and it was multiple hundreds of guardianships, and well, it wasn't a good situation, and so we created this office.
Right. Senator Dorr?
One quick question. It says here it's for 700,000 for one time. Or in the fiscal note. Is this supposed to be an ongoing, or I guess maybe somebody will answer that later too. In the fiscal notes, it's just this fiscal year.
Yeah, there's a problem with that. It should be ongoing. I had a couple of problems with that sort of thing this year with fiscal notes, so we'll see if we can get that straightened out.
All right. Seeing no other questions, are there proponents for LB 761? Welcome.
Good afternoon. Chairman Clements and the members of the Appropriations Committee. I'm Michelle Chafee, MICHELLECHAFFE, and I'm the Director of the Office of Public Guardian with the Administrative Office of the Courts and Probation. I'm here to testify in support of LB 761, a request for appropriations of $700,000 to the Office of Public Guardian to provide services for vulnerable adults in Nebraska who are determined by the court to be incapacitated and in need of a guardian and/or conservator services. The Office of Public Guardian is extremely appreciative of Senator DeBoer for introducing this bill. You're about ready to receive a copy of our 2022 Office of Public Guardian Annual Report to provide information about the OPG. The OPG is relatively a new entity. The legislature enacted the Public Guardian Act in 2015 after abuse and financial exploitation was uncovered of vulnerable adults being served by a professional guardian. When you get the report, I'll go over a little bit more for you, but on page 5 of the report, it describes what the Office of Public Guardian does and who we serve. As you'll see from the graph on page 5 of the annual report, we served 305 individuals in 2022. And due to the various incapacities that they had, these individuals experienced 1,055 complex medical issues and/or social conditions. And by that, I mean that we have individuals who have developmental disabilities, we have people who have dementia, we have individuals with mental health issues, we have individuals with Alzheimer's, we have individuals who have worked with the mental health boards, criminal conditions, etc. So most of the individuals that we work with, and you can see on page 5 of your annual report, are not only co-occurring issues, but multiple occurring issues. So page 5 also of the report describes what, on page 6, the referral sources of the OPG, well, you'll find that very interesting. As you can expect, hospitals and physicians are the #1 source of need for our services. In 2022, we had 94 nominations of individuals who needed a guardian or conservator. And of those, 52 of them were from hospitals. Over the 8 years that we have served, we've served over 907 individuals. 344 of those came from hospitals. Research has shown that guardianship for incapacitated, seriously ill patients is literally a life and death situation. Incapacitated patients without any type of surrogates, account for 1 of every 5 deaths in ICUs, and twice the median length of stay of all other ICU patients. So if you don't have a guardian, a conservative, or a surrogate to oversee, there is a median of twice as long of a stay within an ICU. Vulnerable adults without the ability to make decisions are languishing alone in hospitals with no one to support them or assist in their medical decisions. Many people die waiting. The human toll is tragic, absolutely tragic, but secondary and also important is the cost. Without sufficient appropriate guardianship services, significant healthcare costs are incurred. Studies from Florida, New York, and Virginia provide evidence regarding the annual savings due to public guardianship programs. Virginia reported a savings of $5.6 million in healthcare costs in 1 year with appropriate public guardian services for 85 adults. So 85 adults have been in the hospitals, and it was $5.6 million to hospital and also, I would say, state and public benefit, Medicaid, Medicare. In Florida, there is a savings of $3.9 million in healthcare costs in 1 year due to public guardian services under the study. And the Vera Institute Guardian Project in New York City projected a $2.5 million, and this is specifically in Medicaid costs because of for 111 guardianship clients. So in other words, you served when you were reduced discharged from hospital, it saved the Medicaid payments of that hospitalization. Excuse me. Unfortunately, the OPG has had a wait list for the last 4 years. On page 6, you will find information on last year's nomination data. The OPG was nominated in 94 cases in 2022. And of this February 15th of 2023, I took a look at it for this year's numbers. The OPG currently has 43 people on the wait list, and it also has an additional 20 that are being nominated. They're in the court process. So of these 63 vulnerable adults, they're languishing for care. Of those, 29 of them were from 8 different hospitals that initiated petitions on these cases. The OPG is the last resort for these vulnerable adults. They literally have no one. The Office of Public Guardian wards are totally dependent for everything. So once they are on our wards, we take care of where they live, their medical treatment, the protection of their property, all legal consents, their benefits, their finances, the advocacy for their rights, and ultimately the decision of the end of their life, whether there is a do not resuscitate, whether there's what type of end of life decisions are made by guardians. These are truly vulnerable adults. We are the last option for the unfriended elderly. While we do have individuals who have lived in poverty and on the fringes of society, the surprising truth is we also have served judges, attorneys, pastors, teachers, wealthy single bachelor ranchers, vice presidents of national businesses, and even television personalities. The sad reality is that anyone can find themselves in the need of a public guardian. All they need to be is alone with no one in their life and no one to take care of them and be capable of making decisions. As the annual report describes on page 2, it is extremely difficult to find appropriate services for our wards. Last Christmas, I had 8 of our wards that were homeless.
Now, your time is running out. If
Okay.
you could
I-
conclude.
I will conclude. It was 35 degrees below zero wind chill. And one of them was being discharged from the hospital to not homelessness, to the street, because the person could not qualify for a shelter. So I just want to underscore that the decisions here are important for the funds and the money, but the most important person served are the individuals that we serve.
Other questions from the committee? Senator Dover?
It seems though with, trends in our society with people having less children, having no children, not getting married, divorce, what's the forecast for 10 and 20 years for the increases in this need?
Well, you know that we're in the process of going to have a senior tsunami in our state. And so it not only just the loneliness of like adults and individuals like that, but it also involves the statistics of what our state is looking at. And if you take a look at some of the geography information that has been published, Nebraska is, and I don't want to go into a lot of details with you, but I do want to give you an idea. In Nebraska, we are looking at, in 2009, we had 39,544 residents who were 85 years or older. And by 2023, that we're looking at a 10 times increase. So Americans age 65 will double from 46 million to 98 million in 2060. Nebraska's population, here's the interesting, age 65 is projected to increase from 240,000 in 2010 to 400,000 by 2030, growing from 15% of our population to 24% of our population in Nebraska. So 24% of our individuals will be 65 years and older, and it will be an increase from 240 to 400,000 people. And the greatest impact will be those who are 85 years and older here in Nebraska. And the census identifies that we will have the 8th highest in the nation in regards to individuals that are 85 years or older.
Are there other questions? Seeing none, thank you for your testimony. Are there other proponents for LB 761?
I'm saying.
Hello.
Welcome.
Well, thank you. Chairperson Clements and the members of the Appropriations Committee. My name is Margaret Weppel, Margaret Weppel, and I'm the Vice President of Workforce Quality and Data with the Hospital Association in Nebraska. I am testifying in support of LB 761. After hearing numerous anecdotal stories about the difficulties of transferring patients out of the hospital and into the post-acute setting, the Nebraska Hospital Association began collecting data. This was monthly data on their from hospitals directly in the fall of 2022 and through 2023. According to this data, there has been consistently approximately 230 patients waiting longer than 7 days for discharge to a post-acute setting. Consistently, there have been between 10 and 20 patients waiting longer than 6 months post-discharge for placement. Lack of guardianship is one of the top 10 barriers to discharge and is attributed to those who have the longest delays, those who have been waiting over 6 months. Patients, citizens of Nebraska, are not happy waiting in limbo at a hospital for weeks or months to get an appropriate post-discharge acute setting location. In the summer of 2022, the NHA launched the Transitions of Care Council to monitor and provide solutions for this issue. Members of this council include hospitals, post-acute care professional organizations, and the Nebraska Office of Public Guardian. During these meetings, we have explored the prolonged delays for patients being assigned a guardianship. The Office of Public Guardian has reported they're experiencing staffing and resource shortages. The Nebraska Hospital Association supports additional funds towards increasing the capacity to provide appropriate guardians to Nebraska citizens in need. The funding can be used to increase staffing, resources, and improve guardian retention during this healthcare workforce crisis or shortage crisis. Thank you, and I'm happy to answer any questions. And I do have a question or answer for one of the questions earlier about the number of patients waiting throughout the year. It's a bit different, but we have 92 hospitals, and we collected data from just our systems. So these are the largest hospitals, but there are just 4 systems in Nebraska. And they reported last year that 35,500 uncompensated days. So not quite the same answer, but gives you an idea that we have over 35,000 uncompensated days in those 4 systems last year.
Any other questions from the committee? Senator Dover?
So you said that it's one of the top 10 barriers to discharge. What does it rank in the 10?
We didn't ask for a ranking. We just said, please list your top 10. So I don't know where it falls in that top 10.
All right, thank you.
Seeing no other questions, thank you for your testimony.
Thank you.
Are there other proponents for LB 761? Are there any opponents for 761? Is anyone here in the neutral capacity? Seeing none, Senator DeBoer, you may close.
I might be here in the nuclear capacity. That's what I heard anyway. So.
Nuclear, I almost, yeah. Okay.
That'd be good. So I do want to say that I got information that one of our large hospitals alone had 968 avoidable days for patients awaiting a guardian. So 968 days of people waiting in just one hospital for a guardian that they wouldn't have had to be there. The wait times per patient in this hospital ranged from 127 days as the shortest wait to 329 days on the high end. And that's after they were medically stable and ready to discharge. The cost to that hospital alone is $1.3 million a year. So there is an indirect cost to our state. Part of it is we know that having availability of beds in acute care hospitals is an important thing for our state. And when we have folks that are in these acute care hospitals, it means even if those are in Omaha, it means that, you know, there's kind of pressure all the way on the system. You can't transfer in from other places in other parts of the state if we're taking those beds up for folks who don't need to be there. So, I mean, this is just, it's a bad for patient outcomes. And it's bad for our state as we're trying to make sure that we have healthcare availability throughout the state. You know, there are opportunities for people to have better outcomes if they get to the correct level of care. So that means that if we can get them to the correct level of care, maybe they can get the rehab they need to have a lower total cost later, right? Some of the things that happen to them, just being in a hospital bed can exacerbate the problem by sitting there forever and in that limbo, I think I heard somebody call it, can be a problem too. So I very strongly believe in this program. Obviously, you can tell that. I think that this is
kind of a win-win for our whole state to get people to the right areas that they need to be in a time when we're talking about hospital capacity over and over again, when we're talking about nurses shortages, when we're talking about medical staff in general shortages. It doesn't make sense to me to have people in the wrong place. It's an inefficiency in our system. And if there's one thing I cannot handle, it's inefficiencies. So that is my closing. I would be happy to answer any questions.
Senator Armendariz.
Thank you. One last question. Would the $700,000 completely take care of the wait list?
So that would be 80, and currently there are 96. It gets real close.
$80,000?
No, 80 people.
80 people.
96, it gets close. So it's not going to get the entire wait list. People will still have to wait, but hopefully they will wait less long, even when they are waiting. And obviously, all of those folks that judges just aren't putting them on the wait list. But I thought it would be better to ramp it up slowly, both as a recognition of the fact that there are costs whenever you grow any organization too quickly. So to try and ramp it up slowly to do the best that we can. And also because I recognize the hard job that you all have to do. And I'm so glad I don't have to do with balancing the money and the various needs that we have across our state.
Any other questions? I had a question.
Yeah.
My father was a guardian for more than one person. My brother's a guardian for an elderly lady right now. And I believe I'm aware that after the situation with an unethical guardian, that the laws were made more strict. And lawyers are not wanting to be guardians anymore because of the burden of it. Are you doing anything about maybe simplifying what reporting the guardians have to do?
You know, Senator Clements, that's not a bill that I have this year. That doesn't mean that it isn't part of the whole thing that I'm working on and a longer structure that I'm working on. I think that is part of the solution too, is to just make sure that those are all the right situations, but also without opening the possibility of that, the problems that we had before.
I also have a customer who's a family member, developmentally disabled, and takes care of the brother. And they show me the stack of paper they have to send in just to be the guardians, 50 pages plus, a whole year's worth of very detailed documentation. I would hope somebody would try to work on simplifying that or easing the burden, because my opinion is, perception is that attorneys used to do this and now they really can't afford to for the time it takes and the burden of it. But that's outside this committee's purview, just a comment I wanted to make.
I mean, I think that there is something to be said for that and something we should look at there, but also my understanding is that this is a growing need, or has been a growing need over the last 20 years or so, because folks are less and less wanting to be guardians regardless of the work involved. And that particularly in these cases, these are not straightforward, you've got a person who's more or less able to take care of themselves, or who has a straightforward case. These are pretty complicated cases. I would again encourage you to look at some of those that are highlighted in the OPG's booklet, that these are particularly complicated cases, so that even if we did make those guardianship regulations less difficult, it's not going to probably affect a lot of this population.
All right. Thank you. Any other questions? Thank you for your testimony. That we don't have any position statements, so that concludes LB 761, and that concludes our hearings for today. If you ask about the future of something again,